That was annexed, my lord, page 22 and 23.
No, but this period is not there. 2011 is not there.
Yes, my.
Then how do you explain it?
No, my lord.
Come to para 5. Your leave was granted from 2110 to 2012. 2110, 2012 to 2810. Then 13. Special leave. 1213. How do you explain the first period, these periods? These are not explained.
That period, along with regularized, my lord. 12.
Come to page number 8, para 12 of your affidavit in opposition. This is the period of 561 days shown to have been on unauthorized leave. You have not explained that.
My lord, case 11, my reply, my lord.
Page 11.
Here, my lord, 15/10/2015 to 11/7/2016. And page 10, my lord. (21/10/2012). मला Arvinder me 18/9/2017 to 14/2018. That period, my lord. In termination letter, my lord, column 1.
Page number?
Termination letter, page 20, my lord.
Yes. Yes.
Whereas you have been absent from your duty with effect from 18/9/2017, my lord. Earlier period, my lord, not come in this termination letter.
So what is the this reply which they have given?
My lord, my page 4,
Para 12 of their affidavit.
page 4, para 5, my lord.
This is a long history.
Basically, my lord, at that time I was not in present, my lord, my present and permanent record, my lord. That is why I was not received all letters. My lord, grade 4 employee, my lord.
Yes, who's for the respondents?
And I'm praying for all the respondents. And affidavit has been filed by the department, my lord. It is within the office of the employer is the director of accounts and treasuries. Here is a case before my lord, where there is expressly, my lord, unauthorized absence by the writ petitioner on several occasions.
No,
my
but
lord
you
may
have,
be-
you have proceeded against him
My
in
lord.
respect of the period mentioned in page 20 of the
Yes,
writ
my-
petition.
Yes, my lord. And more particularly, if my lord comes to the affidavit, my lord, filed by my lord, the director of accounts and treasuries,
Mm.
there if my lord may be pleased to come to page 8, paragraph 12.
You have seen that.
Yeah. And my lord, the
This is the
circumstance,
history.
history, and my lord, the circumstances where my lord, the department on various occasions tried to compel his presence on duty. That was also negated by the conduct of the writ petitioner.
No, no, maybe, but you are not proceeding against him in respect of all these leaves.
My lord.
You are proceeding with him only in respect of 18/9/2017. For not mentioned for how many days he was absent. For how many days were you absent from 18/9?
148 days.
Huh?
148 days.
148 leave. And what is the leave to your credit? Is the inquiry report available?
My lord, that is not annexed with the affidavit in opposition also. He has also not annexed, my lord.
He says he was never served it when
Yes,
ex
my lord.
party.
In fact, that is the pleaded case of the respondents hearing. My lord, everything has been spelled.
You get the inquiry report. In fact, you get the records to show whether any notices have been sent and he has received it or not.
My lord. But the circumstances,
But it
have
is
been,
indicate, my lord. In termination letter, indicate, my lord. Letter was not. Letter was
number?
written undelivered.
Page number
Page 20, my lord.
21.
20, 20.
20.
Column number 1. Last line, the letter
Inquiry
was,
report has not been served on you.
yes, my lord. That
Have
was-
you received the inquiry report?
No, my lord.
So let us have the inquiry report.
in fact, my lord, the department went to the extent of, my lord, making a publication in the newspaper. That, my lord, will find at page 19 of the affidavit.
And you did not file any appeal?
No, my lord.
My lord, there is otherwise
He is
an
grade 4 employee, my lord, unaware, my lord.
otherwise alternative remedy is always available because this
You
is,
show us the inquiry report.
My lord, kindly see
Definitely.
para 5, page 20, my lord.
Undelivered.
Yes.
so everything is undelivered. Even therefore, my lord, all the, my lord, envelopes as well as the contents, as well as, my lord, the postal receipts, everything has been annexed to the, my lord, affidavit in opposition.
Reason was disclosed, my lord.
Now, my lord, in my respectful submission, of course, my lordship directs my lord, I will be producing the records before my lord.
No,
But
no,
here-
we'll have to satisfy ourselves with regard to the inquiry.
Absolutely, absolutely. But he, my lord, he is raising question of facts. Those may be, my lord, agitated.
That
before-
we'll see
Yes, my
first.
lord,
First, let us see the inquiry, how it was conducted.
my lord,
What is the inquiry?
my lord.
Hard learned counsels for the parties. This writ petition is filed by the petitioner putting to challenge the order of dismissal dated 14/2/2018 passed against the petitioner, dismissing him from service. Stop petitioner was employed as a grade 4 employee under the Directorate of Accounts and Treasury, Assam 46. Stop. One of the grounds urged in the writ petition is non-service of the inquiry report and the inquiry being conducted ex parte against the petitioner, as the notices purportedly sent to him were never received by him. Stop. The pleadings available on record does not contain the inquiry report. Accordingly, Mr. Porpuzari, learned counsel, appearing for the respondents,
All the rest.
all the respondents, is directed to produce the records of the
Inquiry.
inquiry proceedings against the
My lord.
petitioner, including the inquiry report.
My lord.
Matter be posted again on
Lordship will kindly give me 2 weeks time, my lord. My lord, can it be on 10th of October, my lord?
October 11th.
My lord, my lord.
Okay.
And so, like,
My prejudice.
Yes.
Yeah, Lord, in this case, I am for the response 7. The senior counsel TJ Mohanto has some personal difficulties today.
Mhm.
Senior counsel Mr. TJ Mohanto has some personal difficulty today. It matter Friday or
Not Friday.
Lordship,
After 1 week.
Lordship, in this case, Lordship, he has filed 3 affidavits recently, Lordship. This petition was filed in the year 2019. I have filed my reply against the stay vacating application, but the additional affidavit, he has submitted copies without annexes. That is why I have not been able to file my reply. And Lordship, in this case, Lordship,
Why have you accepted it?
Lordship, I didn't know, Lordship, I didn't check, Lordship.
Then why did you accept it without checking?
Well,
You serve him a copy with the annexures available.
Lordship,
Annexure is there.
there is an interim order, Lordship, that and that interim order was still disposal of the writ petition, but on the last occasion, your Lordship has made it till the next returnable date.
In 5433.
Yes, sir. 5488.
All right. Interim order to continue until further orders. Matter be listed after a week.
And in the second writ petition also, there is an interim order.
Huh?
In the second writ petition also.
All right. In second writ petition also interim order until further order. Side over. Yes.
Lord, in this case, Lord, the petitioners were the relevant point of time was the workers of SCI. They were working in the food storage depot at New Guwahati. Now, in the food storage depot at New Guwahati, there is an arrangement for railway transshipment. The
Railway?
Food grains are carried to the railway wagons, and there is a platform in the food storage depot itself. And these food grains are unloaded and placed before in the platform. Thereafter, these food grains are taken to different shades. There are 6 number of shades. And in those shades below, the food grains are stacked in different racks. And thereafter, if request, it is to be unloaded and sent to the different place of distinction. In that way, ghani bag, the food grain as contained in the ghani bag or plastic bag, get tons. And these ghani bags or the plastic bags, as the case may be, are to be replaced. Now, there is a practice that these ghani bags or the plastic bags are supplied from the concerned office. And there is a practice also that these ghani bags are to be repaired, minor damaged ghani bags. Now, whatever may be the reason is that auditors submitted his report in the year 2014. And in that audit report, the auditor made a remark to the effect that the ghani bag supplied from the office and the replacement of ghani bag does not carry. And as a result, they drew huge amount of incentive. And these incentives are to be deducted from their salary. The wages. That is the basic thing. Now, my lord, this audit report was submitted in the year 2014, 25/10/2014 or something like that. And this deduction was started in the year 2020, 5 years after elapse of 5 years. So we filed a number of cases before this honorable court and we placed this matter. And this court was of the view that so far this case is concerned, it is so there is paragraph 9 of the judgment. On the facts and circumstances of the case, there appears to be no need for the court to return a finding whether the ratio of the case of Rafiq Musa Supra would help the petitioner in any manner whatsoever. As such, the said issue is left open to be decided in a more appropriate case. Now, be that
This is WPC 1094.
yes, 1094, paragraph 9.
Yes.
Now, this court was, honorable court was of the view that yes, it may, when you have started deduction, you should give an opportunity to defend their case. Now, the paragraph 10 has stated, before parting with the records, it is made clear that the order shall not preclude the right of the respondent to hold a disciplinary inquiry or the disciplinary proceeding against the petitioner and or from making recovery after giving reasonable opportunity of hearing to the petitioners in accordance with the procedure prescribed. It is also made clear that nothing contained in this order shall prejudice the petitioners or the respondent in any proceeding whatsoever, which shall be decided in its own merit without being influenced by this order. Now, there are what they have done, they have initiated some proceeding and said, no, we are not satisfied with your reply. That whatever deductions have been made, that is just and proper. That was the finding, Lord. Now, Lord, in that case, Lord, one thing that I could not point it out to the honorable court that about the Rafiq Mufti's judgment.
Yes.
2015 4 SCC 334. Paragraph 18. Married. It is not possible to postulate all situation of hardship which would govern the employee on the issue of recovery, where payments have mistakenly been made by the employer in excess of their entitlement. Be that as it may, based on the decisions referred to herein above, we may as a ready reference summarize the following few situations wherein the recoveries to the employees would be impermissible in law. The first thing is that recovery from the employees belonging to class 3 and class 4 service group in service. We are group 4 service, Ajay. Recovery from retired employees or the employees who are due to retire within 1 year of the order of recovery. Third one is the recovery from the employee when the excess payment has been made prior in excess of 5 years before the order of recovery is issued. I am harping on this point only.
Mm.
Now, recovery in case where an employee has wrongfully been required to discharge duties of higher post and has been paid accordingly, even though he should have rightfully been required to work against the inferior post. 5. This 4 and 5 are not relevant. Till then, let me read. In any other case, where the code arrived at a conclusion that recovery, if made from the employee, would be iniquitous or harsh or arbitrary or to such an extent as would far outweigh the equitable balance of the employer's right to recover. Now, Lord, here in this case, the case was initiated through the audit report. That audit report, your lordship will find at page
You belong to which category?
4, get 4.
Under these criteria, you belong to,
Oh.
you fall under which category?
Oh,
Perhaps number 1 also,
no, 1 as well as 3.
1 and 3.
The court so far 1 is concerned, court was a bit reluctant to accept my view because the court was of the view that it may be a case of fraudulent activities. So they have the right to have initiated a disciplinary process.
No, is there any finding of forgery? Is there any finding that forgery or fraud has been
No.
committed?
No, there is to that effect, there is an observation by this court also. No? That 1094.
These excess payments was made beyond 5 years,
Yes.
prior to 5 years
5 years.
earlier.
Hmm.
From the date of the order passed by the audit.
Audit, that is on 25/10/2014. Your lordship will find at page 14.
Page 14.
At the bottom, audit note number 6, dated 25/10/2014.
Page number?
Page number 14, 14.
Yes. Now, when were the payments made?
Recovery.
No, when were the payments made? 2013 to 14.
Oh, yes, 2013 to 14.
And the audit was in 2014.
2014.
So how do you say it is prior to 5 years?
The deduction was initiated in the year 2020. That your lordship will find.
So the audit came to a finding that this was the excess payment in 2014 itself,
Yes, sir.
but they sought to recover it in 2020,
20.
and therefore Rafiq Mashi.
Recognize. That is one of the grounds. Now, these two things was also the view while delivering the judgment. Now, we'll go to paragraph 5 of this order, 1094. Valid.
Paragraph
5.
5.
The analysis of their affidavit in opposition. Paragraph 4, peruse the materials available in the writ petition and the affidavit in opposition filed by the respondent and consider the submissions made at the bar on behalf of both sides. Now, paragraph 5 is the analysis of this provision. There is no material in affidavit in opposition filed by the respondent which discloses that the petitioners from whom recovery is thought to be made were allowed to participate in audit process conducted by CAG. There is also no material on record from which it can be presumed that the respondent had initiated any disciplinary proceeding against the petitioner, and having granted reasonable opportunity of hearing of the petitioner, arrived at a conclusion to the effect that the petitioner is guilty of misconduct or fraud, or having caused wrongful loss to the respondent. The learned counsel for the respondent has not been able to show from the service jurisprudence that any provisions of this statutory act, statutory rules framed under Article 309, or the standing orders or office memorandums, OMS, issued by the competent authorities of the respondent, which empower the respondents to make recovery of money from the salary of the petitioner without giving them a reasonable opportunity of being heard. Needless to mention here that since no disciplinary inquiry or disciplinary proceeding is shown to have been initiated, submission of charge sheet or the petitioners could not be demonstrated, and consequently the respondents have not been able to show that any order was passed by the disciplinary authority for recovery of any money from the salary of the petitioner. Similarly, the learned counsel for the respondent has not been able to show any adverse remark made by the CAG report which enables the respondents to directly go for recovery without putting the petitioners to notice. It has also not been shown that there is any finding by any court of law holding the petitioners guilty of fraud or excess drawing of wages and or incentive of work shown to be done by committing fraud. Strangely, no document is annexed to the affidavit in opposition to show that an FIR had been lodged by the respondent alleging commission or fraud by the petitioners in convenience with the others. Now, paragraph 6. Moreover, assuming that from annexes C and F of the affidavit in opposition filed by the respondent, that the petitioners had knowledge of the intention of the respondent authorities to recover losses by deducting money from the salary of the petitioner, but no legal provision could be shown that such knowledge is a substitute of show cause notice, which is to well settled requirement of initiation of any disciplinary action against any delinquent employee. Thus, in other words, the recovery is thought to be made from the salary of the petitioner without any finding to hold that the petitioners were guilty of fraud or any other misconduct, and or that they are guilty of fraudulent withdrawal of money sought to be recovered. There is nothing in the affidavit in opposition filed by the respondent from which it can be gathered that amount of money sought to be recovered from the petitioner has been quantified after putting the petitioners to notice. In the affidavit in opposition filed by the respondents have not produced any order in writing that was served on the petitioners before starting to deduct any money from the salary of the petitioner. All these things are in my favor. Now, paragraph 8. Therefore, in the light of the discussion above, the court is of the concerned opinion that the action of the respondent under the facts of this case is not found sustainable on facts and in law. As such, the court has no hesitation to set aside the action of the respondent in effecting recovery of money from the salary of the petitioner on account of alleged fraud committed by the respondent without disclosing before the court regarding passing any written order to that effect. Resultantly, the respondents are jointly and severally restrained from making any recovery from the salary of the petitioners on account of finding returned in CAG audit report dated 24/10/2014. So despite that, no recovery was made, and after
This observation at para 7, initial observation, beginning of para 7.
Hmm.
Learned single judge has arrived at this, has observed. On what on what basis this observation was returned?
No, they filed an affidavit. According to them, that their fraud was committed. The learned single judge was of the view that there is.
They allege that fraud was committed.
There, as per their affidavit, the learned single judge was of the view there is no material to suggest that
Okay.
any fraud was committed. And as such, the recovery which you have made, it is not tenable and it was set aside. However, what problem created by the observation made by paragraph 4, that this gave them a handle. Before parting with the records,
Para?
para 10. Para 9, this is on the facts and circumstances of this case, there appears to be no need,
Rafik Marshi need not be applied.
who shall examine it in appropriate case. And the said issue is left open to be decided in a more appropriate case. Now, paragraph 10, that has created a problem for me. Before parting with the records, it is made clear that order shall not prejudice the right of the respondent to hold disciplinary inquiry or disciplinary proceeding against the petitioner and or from making recovery after giving reasonable opportunity of hearing to the petitioner in accordance with the procedure prescribed. It is also made clear that nothing contained in this order shall prejudice the petitioners and the respondent in any proceeding whatsoever, which shall be decided in its own merit without influence by this order. Thereafter, what happened, my lord? The petitioners were served with some notice, and they were called upon to submit their reply, and they submitted their reply, and accordingly it was said that we are not satisfied. So whatever recovery we made, that is just and proper, and we have upheld that order in this honorable court.
Yes.
For my present, my lord, what I would like to say, my lord, whatever me the case is, the Rafik Mushi would apply here.
Sorry,
Rafik Mushi,
where is the impugned order again?
there is no such impugned order, but the deductions are there.
No. After this, what happened? After the order passed by the writ court,
It code in another case. Here the petitioners are different. 109.
okay. They were not filed by the same petitioner.
But they are relying upon this judgment. But they are
Now,
similarly
is
situated.
this order not applicable to you?
No, is this order is, so far my case is concerned, whether this Rafik Mashi will be applicable in this case or not.
No. Rafik Mashi applicable, not applicable. The ratio of this order, is it not applicable? This court, the coordinate bench has come to a finding that there is no finding on fraud.
Yes,
Therefore, this recovery cannot be made.
yes. That was the finding.
Is it a similar stand taken by the respondents here? In your case?
Same.
Same.
Same
So why
thing.
is it not covered? Why should it not be closed in terms of this order?
Because of the fact that Rafik Mashi will be covered by this case.
No, but how are you prejudiced by not coming to a finding that Rafik Mashi case whether applicable or not applicable?
I will be prejudiced by the observation made by this honorable court at paragraph 10. At that point of time, I could not understand.
Disciplinary inquiry.
Court gave an opportunity to hold it appropriately. But apparently,
No,
it
but
was against
this cannot be interpreted to mean that this will give a right to the respondents to go beyond Rafik Mashi.
Yes, that is my
It
case.
cannot.
No.
It doesn't require any clarification. You are asking for a clarification. Essentially, what you are asking for is a
No, because
clarification
this
of para
observation
10.
made in paragraph 9.
No. What you are asking for is the notwithstanding observations in para 10, Rafiq Mashi will apply. But does it require any clarification? Rafiq Mashi is binding.
But that.
The learned court, the court
The learned code.
has
Well,
given you,
Actually, it was to some extent. I am
coordinate
also-
bench perhaps has given an opportunity because they have raised the issue of fraud.
No, learned code making an observation to that effect that the audit report was made on 25/10/2014. Thereafter, it was my duty, it should have been my duty to point out this paragraph. And as a result, this order is a par inclusion.
Yes, what do you say, Mr. Roy?
My lord, after the,
Is it-
your lordship,
is it
my
your-
learned friend has read the order passed by the coordinate bench.
Would you like to submit that you can go beyond
No,
Rafiq
no, my lord,
Mashi
Rafiq
in
Mashi is
view of
kept
para
open.
10?
After the order is passed,
Huh.
we have initiated the process, we issued show cause, they submitted reply, inquiry is held
To these petitioners,
to these petitioners.
present petitioners?
Yes, the orders are here.
Huh.
The final order is passed.
Huh.
So, my lord, they will have to put a challenge to this order.
No, what is the order?
Order is, the earlier order, they are held guilty, my lord.
But
the
that
earlier-
is opposed to Rafiq Mashi.
No, Rafiq Mashi, my lord, Rafiq Mashi case says that if there is a mistake, it is not a case that there is a mistake. Because the office staff and the.
No. I subject to correction. Rafiq Mashi has laid down a criteria by which you can recover.
It says, Rafiq Mashi says, my lord. Rafiq Mashi, I'll read it, my lord, para 12.
Yes.
It says, I mean, I don't know, but in my case, it is Manupatro, my lord. It could be,
Huh.
my learned friend has read.
You read the opening lines?
It says it is not possible to postulate. Lordship got it, my lord. It is not of, last, I think the last paragraph,
Paragraph 18 in SCC.
it may be 18, my lord. SCC 18.
Yes.
It is not possible to postulate all situation of hardship which would govern the employees on the issue of recovery where payments have mistakenly been made by the employer. It is not a case where payments are mistakenly made.
Why were they made?
They are made because they were shown access to the job. Beyond their entitlement, they received the money. They were given the war
Huh?
to unload a particular depot. Supposing 100 bags, they have shown it to be 500 bags.
Who have shown it?
Both the department levers and the employees together.
Huh.
Because the department
So are you
level.
alleging fraud on the employees?
Yes, that's a fraud, my lord. Clear case of fraud.
Only for the employees, not for the railway authority.
The authorities are also, my lord, they're taking, well, I think they should be held also equally, but they cannot, my lord, be absolved. They cannot be absolved. Therefore, my lord, I said, my submission is, since there is an already order passed by this honorable court, my lord, altogether, my lord, 10 writ petitions are filed at the same time, on the same day, and 4 were disposed of by this order, my learned friend has read. And the remaining 6 are before your lordship. Same orders, same challenge, same prayer. Same, at the same time filed. 4 were disposed of by this order. Why not the remaining 6 should go in the same line? And more because of the fact that after the order passed by this honorable court, we have complied with and held an inquiry, giving them show cause notice in terms of the order passed by this honorable court. They have submitted a reply, inquiry committee was constituted, inquiry committee submitted a report. After that, final order has been passed. So, my lord, they will have to put a challenge. Even the other petitioners, I think whose case are disposed of will also be required to put a challenge. I think one or two may have filed a writ petition already.
No, but how do you come out of the findings of the coordinate bench?
No, my lord, if your lordship, because there is already an order,
No,
if
no.
lordship passes the same order, I cannot have an objection to the law. But what
No,
is the effect of this order?
kindly come to that 1094.
1094 order. Yes, my lord.
Paragraph 9.
Paragraph 9 said Rafiq Masih
No, para 5, end of para 5.
and para 5 says, because we have not issued show cause, therefore, there is no record. There is nothing on record to show that they were party to the audit process. They were aware of this recovery, the action taken. And therefore, my lord, the court has held that there should be an inquiry. There should be an inquiry said all these observations will not be, will not come on our way. And the last paragraph, my lord, is see, last paragraph, para 10, says, it is made clear that nothing contained in this order shall prejudice the petitioners as well as the respondents. Therefore, my lord, your lordship will have to ignore para 4 and 5. Ultimately, para 6 says, this will not come on our way to hold an inquiry. Para 10 says. Because of the 3 lines in para 10 at the end, but the other observation made has to be ignored, my lord. In terms of this, we have held an inquiry. There is an order passed. So they will have to put a challenge to this order.
Maybe he's right. It appears to be that there is a liberty granted.
But so far, this case is concerned, nothing liberty was granted. Then how they can hold this inquiry?
Hmm?
So far, this case is concerned, how they can.
There is no bar also.
How they can hold an inquiry in terms of the earlier, some other cases.
Maybe, but there is no bar. There is no bar that they cannot hold an inquiry.
No, because they have been put
Now
granted a
the-
license to hold their inquiry.
No. Now you appeared in this matter, is it?
Yes.
Earlier matter.
Oh, yes, sir. I appeared earlier.
So
So far, earlier matters are concerned. all right.
Earlier
So far,
matters-
those cases, they have hold inquiry in terms of the
Uh,
order. Now, because of this, in some other cases, this inquiry was, this order as well, how they can apply this here?
no, because this order, assuming we are to dispose of your petition, we have to refer to this order.
Yes, yes. And while referring this order, probably your lordship have to refer our paragraph 9.
Para 9.
Whether the Rafiq Masih is applicable or not. And my respectful submission that this order is far inferior, my lord, because this point was not asked, could not be asked.
Which point?
That after 3 years after reduction was started, 5 years after the reduction was started, this was not the issue before the lordship. And as a result, this order was passed. Now subsequently, it has been detected. So
No, the coordinate bench
the coordinate bench
did not
passed an order.
arrive at a finding, that the principle of Rafiq Masih is applicable or not applicable.
Yes.
Did not arrive at a finding. Now-
We shall examine in a
Now,
further effort.
in your case, we could have examined this.
Yes.
But for the fact that there is subsequently some inquiry being initiated also, rightly, wrongly, some
No,
inquiry.
If it is wrongly initiated, then it will
But
be
that
stopped
has
up.
to be assailed for us to interfere or look into the, for us to hold that this inquiry was also not required. Or even
No, I-
notwithstanding
I-
this,
Receive this report. Very good, Professor. So far, this petitioners are concerned.
Yes.
they have held an inquiry against you.
All the petitioners, the final order,
All
they
the
they're served with this order.
Hmm?
Served with this order. They have participated in the inquiry,
No,
served
no.
with it.
Some
Well, I
notices
think-
were served.
I-
Yes, sir, I had been done. They have supplied the,
I can
submitted the
hand up.
reply also.
Yeah.
Anyway, look, whatever may be, if they have done something wrong, it can be stopped it off. Because of
strike
the
it off,
fact,
to strike it off, you'll have to assail it, you'll have to bring it on record. As on date, it is not there. It's only a mere submission made. We want to know that pursuant to this order, whether any proceedings have been initiated or not. If not, we can take up this matter and decide. Maybe we'll accept the view of the coordinate bench. Maybe in case we defer, we'll have to be referred to a
I
larger
think,
bench.
my learned friend is not properly instructed.
No, I have, so far this case is concerned, I don't think they are the petitioners. Rajkumar Shah.
প্রত্যেকটাই আছে। Petitioner-
All right, this is the only tip.
ঠিক আছে, না হ্যাঁ, এইগুলো একটা একটা করে অর্ডার দিলাম।
আমারই কেসে, আমারই কেসে।
হ্যাঁ, সব সব all
এখানে 6টা, total 6টা।
six
ছয়টা
petitioner, six।
কটা মানে এখানে আমার তো petitioner আছে 13টা।
না, 13টা আগের গুলো তো আর এখানে নাই।
না না, যে আজকে কেস 2টা উঠতে গেছে।
8টা আছে।
আরেকটা?
8 petitioner।
টোটাল তো আজকে 6টা পিটিশন উঠছে।
না, আপনি এই কেসে করে
এই কেসে না, মাত্র লিডিং যারা ছিল।
let me take it up now. I don't think it's covered.
Huh?
Let me take it up. Because I don't find any name so far this petition is concerned. Ushu Sahani,
সুসানি আছে।
Suhani আছে। Ushu Sahani অন্য কেসে। Ushu Sahani আছে। Very different case. Rajkumar Sahani.
সব clear।
They will have to-
He is the only order.
না, আরো সব পার্সোনাল ডিসপোজাল
No, I should do this. So far this case I don't
হ্যাঁ,
have.
হ্যাঁ, six-
So, no, so far all these six cases, this will cover. Here there is a 6 cases.
6টার মেইন যেগুলো পিটিশনারের নাম আছে।
দেখো, here there is a from item 2 to item 7.
হ্যাঁ।
6 cases are there. So what you want to say that all these persons were departmentally prosecuted and orders were passed. And in support of that, you gave me this order. But I don't think
the একটা কেসে যেগুলো petition about
Petition number one
you have to collect, you are also part of the inquiry.
no, so far this case is concerned, I don't find any name here. Not a single name.
Did you actually conduct any?
Yes.
How?
Well, Lord, the show cause was issued because in
Were
fact,
you not aware
they
this
are-
writ,
they are
were
not-
you not aware this writ petition was pending?
no, after the writ petition is disposed of,
We are asking you the inquiry in respect of the present petitioners.
Yes.
Have you conducted any inquiry?
this is the orders.
This is the order
Yes.
against,
Against the petitioner, the six first petitioners, the lordship will find Chiranjeev Care, it is there. Petition after the order is passed.
we are asking you a simple question, you are unable to answer us. This writ petition contains about how many writ petitioners?
8.
8, 14.
14, but
14.
my lord, I have not brought all 14. I have done the petition number 1 in each case.
Was he a petitioner in the earlier case also?
No.
Earlier case, no, earlier case, they are not the petitioners. Earlier case, if the lordship wanted
You
also-
proceeded,
against all. Earlier case and the present petitioners all, and simultaneously.
without leave of the court,
Well, Lord,
without any leave of the court,
the court has given the direction.
in
Lord.
respect of those petitioners.
No, but then those petitioners, but we have initiated because since the liberty is granted, we thought. my lord, we
Liberty
should-
is granted with regard to those petitioners.
All right, there is no stay.
May not be, but the fact that you have
But
proceeded
then that,
during the pendency.
all right, my lord, that will have to test it, we'll have to place this on the court, then or everything.
Oh, when was the notice
There
issued
is
here?
no bar, my lord, for us to.
There is no bar, but is it proper for you
Because
to
we cannot leave,
render a writ petition infructuous by
no, we have. no- my
pursuing
lord,
with
in fact,
an pursuing
we
with
cannot
proceeding?
leave, my lord, we cannot leave one set and issue
We
notice.
don't know
to
what
them.
you can do, you cannot do. Notice was issued on 22/3/2021,
Lordship,
and your presence was recorded
lordship.
for the respondents. When did you continue with this?
After the final order passed the other cases.
So this is pursuant to the notice,
First.
pursuant to the
first
notice
is
here,
Notice.
pursuant to the fact that you are aware that there's a writ petition pending.
That's right. When writ petition is notice stage, it is
Maybe,
not admitted.
does it give you the liberty to
No,
render
it's
a
not.
writ
It
petition
does not. It does
infructuous?
not. No, your lordship is right. Technically, lordship is right, but not, since it is there is a pending notice was issued, but then rule was not issued. Then the authority.
Mr. Counsel,
The lordship
you're a
is right.
counsel. And
No,
that
no, your
was,
lordship is right.
that was
Absolutely.
senior counsel.
Lordship is right, quite right, my lord. That since petition
This
is
is not a
pending,
conduct expected for the railways.
not true.
That you're trying to pull out the carpet.
Oh, no, we are not railways, my lord.
Sorry, FCI.
That's it.
During the pendency, you knew
No, since my lord.
the whole
lordship
purpose
is-
of
lordship
the
is
whole
right.
purpose of conducting the inquiry is to render the writ petition infructuous, which is your submission now.
No, lordship is true. Lordship is right. It does not, as
This is
such,
not
they can
proper.
put a challenge, they can put a challenge to this. They can put a challenge to this.
You should be grateful they have not put a challenge, because if they put a
The
challenge,
lordship
we
is
don't know what orders would be coming from the court.
Absolutely, absolutely. That's right. Absolutely. Authority ought to have waited, but then thought, that since there is already an order, judicial order, so you must comply. with
Heard learned counsels for the parties. This writ petition is filed by the petitioners putting to challenge the recovery sought to be made from the petitioners in respect of what? Wages,
recovery, incentives.
recovery of incentives. Where is the annexure? Impugned order,
Annexer D, etc.
page number.
Annexer C.
Impugned recovery of incentives pursuant to audit report. Is it audit report?
Audit report dated 25/10/2014.
Page number 13A.
The relevant page is 14. 17.
Pursuant to audit report dated
25/10/2014.
25/10/2014. Stop. Notice in the matter was issued as far back as
There is already an order for
20
praying for amendment.
22/3/2021. And the respondent councils were also represented. Meanwhile, a similar set of similarly situated writ petitioners approached this court by another writ petition being WPC 1094 of 2021. This writ petition came to be disposed of on 25/8/2021. Stop. The coordinate bench arrived at a conclusion that the recovery sought to be made from those petitioners is not supported by any finding or order of the court that that they were guilty of fraud, end oblige misconduct, or guilty of fraudulent withdrawal of money which has subsequently been sought to be recovered. Stop. While disposing of the matter, the coordinate bench, in its wisdom, observed that the ratio of the judgment of the apex court rendered in Rafiq Masi, reported in so and so, need not be delved upon, and kept the issue open to be decided in a more appropriate case. Stop. The coordinate bench, however, the uh, the coordinate bench further ordered that this the order disposing of the said writ petition being WPC number so and so shall not preclude the rights of the respondents to hold disciplinary inquiry or disciplinary proceedings against the petitioners within bracket therein, and or making recovery after giving reasonable opportunity of hearing to the petitioners in accordance with the procedure prescribed. It was made clear that nothing contained in the order of the coordinate bench shall prejudice the petitioners or respondents in any proceedings whatsoever, which shall be decided on its own merit without being influenced by that order. Stop. Pursuant to the disposal of the writ petition, the FCI authorities proceeded to initiate an inquiry against the writ petitioners in WPC 1094 of 2021. And it is submitted that the inquiry has since been concluded with the inquiry with the competent authority passing appropriate orders thereon. Stop. It is further submitted by the learned counsel, senior counsel appearing for the FCI, that in view of the liberty granted by the coordinate bench in WPC 1094 of 2021 to proceed for inquiry, the department proceeded for a similar inquiry in respect of the present petitioners in the instant writ petition. Stop. And orders have been passed. Stop. Para. Having heard learned counsels for the parties and upon due perusal of the materials available presented before this court, it is seen that in the present writ petition, the argument, the basic thrust of the as projected by the petitioners is that the recovery sought to be made from the petitioners by the FCI authorities is in contravention with the principles of law laid down in Rafiq Mashi within bracket Supra. Stop. While the learned senior counsel for the petitioner does not dispute that similar issues were decided by a coordinate bench by rendering the order dated so and so passed in WPC 1094. He submits that in the said order also, the applicability of the principles of the law laid down in Rafiq Mashi was left open to be decided in an appropriate case. Stop. Learned senior counsel urges that in the present proceedings, he places strong reliance on the judgment of Rafiq Mashi to support his contentions that the recovery sought to be made could not be made as the petitioners belong to grade CND posts and the recoveries have been sought to be made beyond 5 years from the date the order of recovery was passed. Stop. That apart, it is submitted, he submits that the conduct of the FCI authorities in proceeding to in proceeding with an inquiry on a leave granted by a coordinate bench in a separate writ petition is an attempt to render the present writ petition infructuous when the department duly represented by his counsel was aware that the writ petition with the issues raised in the present petition is pending disposal before this court. Although no interim order was granted, however, it was expected that the department ought to have at least brought to the notice of the court and sought leave for proceeding with any inquiry as may be, as they have purportedly sought to have proceeded against the petitioners. Stop. He therefore prays leave. He, however, does not have the complete instructions. He submits that he be permitted to bring any such inquiry or notices that may have been served on the petitioners by filing additional pleadings before this court, and the same may also be considered for by this court at the time of hearing of the matter. Para. Mr. Roy, P.K. Roy, learned senior counsel appearing for the FCI, submits that since the leave was granted by the coordinate bench in WPC 1094 of 2021, the authorities in their wisdom thought it fit to proceed with the inquiry against not only the petitioners in WPC 1094 as well as all other similarly situated persons, including present writ petition. So he, however, admits that the department ought to have brought it to the notice of the court or sought liberty from the court before proceeding with the inquiry. We are recording your submissions. If you have an objection, please tell us. In as much as in view of the subsequent inquiries being conducted, the issues raised in the petition ordinarily would not require any further decision, more particularly in view of the order dated so and so passed in WPC 1094 of 2021. Para. Having heard learned counsels for the parties, we find that the liberty granted in WPC so and so by the coordinate bench was in respect of the petitioners therein. So the writ petition, notwithstanding it raises similar issues, the question of applicability of the principle of Rafiq Mashi of the judgment of the apex court within bracket Supra had been kept open by the coordinate bench in its earlier order dated so and so, passed in WPC so and so. And therefore, if required, this issue, there is no bar for this court to decide on this issue of applicability of the principles in respect of the present proceeding. Stop. However, if the subsequent inquiry conducted by the FCI during the subsequent inquiry conducted by the FCI against the petitioner during the pendency of the court, this case, notwithstanding no interim orders being granted, such conduct of the FCI, such actions of the FCI has the potential to render this writ petition infructuous while this court is in session of the matter. Stop. Under such circumstances, we permit the writ petitioners under such circumstances, we permit the parties to bring on record the notices as well as any orders that may have been passed in respect to the petitioners of such inquiry that may have been conducted by the FCI pursuant to the order dated so and so passed in WPC 1094. Matter will be considered upon the pleadings being exchanged by the parties thereafter. List after 4 weeks. We are
Yes, we can
permitting
list it.
both parties to bring on record if you want.
After, it will come after the 4 weeks.
Date may be put, and
No, let us file the pleading.
Give a date after 4. You may take it back.
I'll put it on record by filing. In the-
You should advise your clients not to.
No, that's right. They didn't understand the purport of the.
8th of November.
We are giving you 4 weeks because we are leaving it to the option of both parties to bring it on record. Whatever documents you want. If you say you can bring it earlier, can,
Have to instruct my client that
all right, then. We take the date, 8th November. 8th of November.
Lordship, on 12th, they have filed an additional affidavit. Lord.
Hmm?
On 12th, Lordship, they have filed an additional affidavit. Lord. So I would like to respond to that.
My lord, the matter, my humble submission, that my lord, matter is pending since 2021, my lord. The
Dismissal
petitioner is
from
jobless,
service.
my lord. He was a CRPF, my lord, constable, my lord, and he has been wrong, most illegally, my lord, removed from service, my lord. So if matter is heard today, my lord,
Where is the order of removal? Order of removal.
yes. Yes. My lord, before going into details, my lord, I would like to summarize what the fact, my lord, what happens, my lord. But in this case, my lord, petitioner, he took leave for marriage of his sister, my lord. Thereafter, he came to his hometown, my lord. Thereafter, my lord, his
Mr. Roy, we will just hear the
Lordship.
facts and then if
Lordship.
required, we'll
Lordship.
permit you. Yes.
Lordship.
Thereafter, what happened, my lord? His sister's marriage somehow postponed, my lord. And thereafter, my lord, he suffered mental shock also, my lord. And he became a psychiatric patient, my lord. He thereafter made treatment at Silchar Medical College Hospital, my lord, for a long time, my lord. His wife also made an application to the authorities, my lord, for paying for extension of leave, my lord. Thereafter, my lord, when he was somehow better, my lord, he joined office, my lord, at New Delhi, my lord. Then thereafter, my lord, what happened? They issued show cause notice, my lord. And he also submitted his medical documents, papers relating to his illness, my lord. And even their doctor also, there is a certificate I have annexed, my lord. Anyway, during investigation, inquiry officer, my lord, inquiry officer recorded that exhibit 15, 16, 17, these 3 documents belong to petitioner, medical document and wife's application, my lord. Then what happened, my lord? They have jumped into conclusion that I am by plea is a false plea, my lord. My humble submission is that, my lord, as per Rule 27C, sub Rule 5, my lord, if any document is admissible, if it is admitted, my lord, then reason has to be given why, whether they are accepting my ground or not, my lord. What inquiry officer has done, my lord, without giving any reason, my lord. He has simply stated that these are the documents I have submitted, but without going into merit of those documents. My lord.
You participated in the inquiry.
Yes, my lord. He participated, but he did not adduce any witness. He himself given his evidence, my lord. Then that is one part, my lord. I have 3-pronged argument. That is one part, violation of this provision of law, my lord. Then second part is that, my lord, during inquiry process, my lord, presenting officer, although appointed, my lord, but what happened, he has played no role at all, my lord. I will show you, lordship, from the inquiry report as well as findings in the impeachment finding, my lord. And the inquiry officer himself, my lord, played the role of prosecutor, my lord. That is second point, my lord, argument, my lord. And a third one
No.
is
Is there a presenting officer or inquiry officer? Both.
inquiry officer himself, my lord, the role, the nature of role he played, my lord,
Ah.
it shows that he has taken the job of prosecutor also, my lord. That will come, my lord. Then third point is that, my lord, disproportionate, my lord.
punishment.
Yes, my lord.
What was the punishment?
Removal is disproportionate, too harsh, my lord.
What
So
is that
now-
removal?
No.
Removal.
Removal. I've been removed, my lord. So, my lord, I'm first, lordship, I'm taking to inquiry report. That is, my lord, page 44, annexure 8, my lord. And relevant portion, if lordship wants to see, then I can show lordship relevant portion also.
Hmm.
Page 54, if lordship goes, then
54.
I can give a summary of the matter, my lord. Page 54, my lord.
Hmm.
In the course of inquiry, the charged official adduced the following document. Slip
Yes.
dated 4/5/2019 with regard to the treatment of mental stress of the charged official in Negrims, Meghalaya, my lord. That is exhibit 15. Then, my lord, second document, letter dated 18/6/2019 of the wife of the charged official to the commandant praying for extension of leave. That is exhibit 16. That's okay, my lord. Third one is,
Where are your medical documents?
that is one is exhibit 15, my lord.
Page number?
That is, I am not having this document, my lord, already submitted to the department, my lord. At present, I am not having, my lord. It may record, it may reveal from the record, my lord. Then third one is that, my lord, slip with regard to the treatment of mental stress of the charged official in Silchar Medical College and Hospital, my lord. Exhibit 7, my lord.
You have no document for your medical status. Your
Yes,
medical
I have submitted some documents, my lord, before that.
Inquiry.
Yes, my lord. I have annexed, my lord, a lot of documents, my lord, during those periods, my lord. That is, I have annexed, my lord. I am going.
And what is that
my lord.
additional
No.
affidavit you have filed?
No, my lord.
Some affidavit in reply you have filed.
Additional affidavit filed on,
Huh?
Yes, my lord. Additional
on 12/9,
Additional
2020.
affidavit also.
Lordship. On
To what
12/9.
effect?
To that effect that the presenting officer and the inquiry officer has played the role of presenting officer. So that earlier they have not taken that plea, Lordship. Now then 12/9 they. If my lord want to
No,
look
my
at
lord.
the medical certificate, Lordship, what I have the record, Lord. This is the medical certificate.
My lord, reasoning part given in page 56.
Hmm.
This is the medical document he has submitted.
He has some medical problems as per the report.
As per report, yes, Lord.
Then what is your
Lordship is a
Procedure.
habitual offender, Lordship. Kindly see he was habitually offender, Lordship.
Huh?
Habitual offender, Lordship. Kindly see our affidavit in page 6, Lordship. We have given the details, Lordship. In spite of this, he has not.
My lord, on earlier occasion, my lord,
Hmm.
I had to take leave, my lord, unauthorized. I was absent, my lord.
On
But
5
that was
occasions,
on
Lord.
different ground, my lord. Not
Where is the
medical,
inquiry report?
hell ground, my lord.
Lordship,
And that was condoned also, my lord.
Not on record.
it is on record, Lordship.
On record.
Page 50 in the writ petition, Lordship.
In the writ petition.
Lordship, 46, the report of the inquiry.
Okay.
Shall I read this report, my lord?
Inquiry report?
Yes. Introduction. Page 46. I was appointed as the inquiry officer by order number dated 28/10/2019 of the Office of the Commandant Battalion CRPF to prove the charges framed against Fort Ranjan Singha. Subsequent to the appearance of Fort Ranjan Singha before me in presence of the presenting officer, the inquiry was commenced on 1/11/2019. In course of the inquiry, the statements and cross-examination of the witnesses were recorded. While furnishing copies of the statements and cross-examination of all the prosecution witnesses, after recording the same and all the papers and documents to the charge official by letter number dated 6/11/2019, the charge official was informed that if he intended to produce any witness or document in his defense, he should produce the same within 15 days of receipt of the letter. Thereafter, on 20/11/2019, the charge official himself appeared, made his statement in his defense, but he didn't produce any other witness in his defense. After conducting the departmental inquiry impartially to prove the charges framed against post number so as the EU inquiry officer of the inquiry, I submit the inquiry report on the basis of the statements of all the witnesses and documents produced before me in course of the inquiry and the brief notes of the PO to the following effect. Participation of Force Ranjan Sinha. During the preliminary hearing, the charge official force number so was informed that I, Sri Ankit Kumar Gupta, Assistant Commandant, was appointed as the EO by order dated 28/10/2019 to prove the charges framed against him. The charge official was asked if he had any objection with regard to the EO, whereupon he replied that he had no objection with regard to the EO. Thereafter, the statement of various witnesses and their cross-examination were recorded during the inquiry. After recording the statement and cross-examination of the witnesses, copies of the statements, cross-examinations, and all the documents were furnished to the charge officer by letter dated 6/11/2019 with an instruction that if he intended to produce any witness or document in his defense, he should produce the same before the EO within 15 days of receipt of letter. On 20/11/2019, the charge official himself appeared, made his statement in his defense, but he didn't produce any other witness in his defense. On 20/11/2019, the presenting officer, Suresh Kumar, was asked to submit his brief note, and accordingly, he submitted his brief note on to the EO on 23/11/2019, my lord. That was the work done by presenting officer only, my lord. He submitted a brief note, my lord. And apart from that, my lord, he has played no role, my lord. Points of charges framed against force number so. The following charges were framed by memo number dated 18/9/2019 against force so. Annexure 1, charge 1. While serving in the capacity of CTGD in battalion.
What, one
Yeah.
minute, what reply you want to file against the additional?
Lordship, they have stated that the presenting officer and inquiry officer has no role to play. Here, they have made an allegation, Lordship. We have to respond to that affidavit.
What allegation? This is an argument he's made. Are there any additional facts to?
No, Lordship. That
Then-
it was on 12/9 on reply, they have not stated anything. Suddenly on 12/9, they have filed an affidavit. Lord.
My lord, the settled position on presenting officer is that, my lord, even if, my lord, in a departmental proceeding, presenting officer is not appointed, my lord, that also will not vitiate the proceeding, my lord. But the thing is that, my lord, inquiry officer cannot play the role of prosecutor, my lord. That is my submission, my lord. Even
What
in
are
absence of
you relying on any proposition?
So, my lord, it will be clear, my lord, if we continue with this finding, my lord. Annexure 1, my lord. While serving in the capacity of CTGD in battalion, and while being a member of the force, as per the provision of section 11(1) of CRPF Act 1949.
The allegation against him is what? Remaining absent,
Yes. Unauthorized.
unauthorized. That's all.
Yes,
That,
Nothing like violence against
no.
fellow members or
No,
insubordination.
No. Only unauthorized.
Only unauthorized.
Earlier occasions also, he has done this. We have warned
He was
him, but
appointed as what? Constable,
constant.
general duty.
Lord.
my lord, what they have given the finding, my lord, that reasoning, page 56, my lord.
Yes,
Shall I read page?
yes, read.
Continue, okay. Annexure 1, charge 1, annexure 2, charge 2, annexure 3, charge 3, my lord. These three charges were framed, my lord. Departmental inquiry is conducted force number so and so, in his presence. The accusation.
No,
against
what
him
I'm
given in
asking
article
you
of-
is that all these three charges are essentially against unauthorized leave. Or is there any other charge?
No, my lord, only.
Only
for-
unauthorized
for Being unauthorized absence.
at
or-
different
Yeah.
periods of time.
But another thing is that, my lord, that whole period cannot be considered as unauthorized because, my lord, my wife has submitted an application for extension of leave, my lord, during that period, my lord. But neither they have made any rejection or considered the same, my lord. So they cannot take the whole period as an unauthorized absence, my lord, because my wife has intimated the department, my lord. So, my lord, if I draw the lordship attention to page, analysis is at page 54, my lord. 54, my lord.
Uh,
Analysis of the departmental inquiry, my lord. How they analyze it, my lord. In course of the inquiry, the statement of the witnesses and their cross-examination and the document required for the inquiry were received keeping the principles of natural justice with regard to force number so and so, so and so. The charge official Ranjan Singha was given ample opportunity to defend him during the inquiry. From the statements of all the witnesses and documents, it appears that the force Ranjan Singha was sent on casual leave for 15 days from 14/3/2019 to 2/4/2019 with RH on 17/3/19, 24/3/19 and 31/3/19 and GH on 23/19 and 21/3/19 to attend his younger sister's marriage, PW 1234 Exhibit 12. The official was supposed to report in the TC Jammu in the night of 2/4/19, but he didn't report and remained absent, a deserter from 3/4/19 without the prior permission of competent officer. And owing to that, the information of the absence of the charged official since the time of his leave was given to the battalion headquarters through WT message dated 4/4/2019 of Central Company, through WT message dated 21/4/19 of the company. Information of stopping the salary and allowance of the official was given to the battalion. Furthermore, force number so Ranjan Singha was directed to join his duties by sending letter to his home address by registered post. But the official remained absent from his duties without giving any information. Hence, the details of the official were furnished to the battalion headquarters company for issue of warrant of arrest against the official. Consequently, the office of the commandant issued warrant of arrest against the official and sent the same to the superintendent of police, Hailakandi, Assam. As the official remained absent for more than 60 days from his duties since the time of his leave on 4/7/2019, the commandant CRPF constituted judicial inquiry committee. After remaining absent for 155 days, the official reported to the battalion headquarters on 4/9/2019, and therefore the warrant of his arrest issued earlier was cancelled through the office of the commandant battalion. The information of releasing the salary and allowance of the official was furnished to the battalion headquarters by company so and so. Keeping the this is very important,
you
madam.
are not, you do not dispute that you suffer from mental illness.
Yes.
Do you dispute that? No.
What, my lord?
Your medical condition, you accept
Yes, my lord.
that you are suffering from
Yes, my
mental
lord.
instability.
Yes, my lord. When I arrived there, my lord, I have been got treated by their doctor, my lord, departmental doctor, my
That's
lord.
what I'm saying. Departmental doctor has rendered some finding.
Uh,
Do you disagree with that finding or?
No, my lord, there was no medical board was constituted, and only, my lord, on arrival, my arrival to the department after joining, my lord, I have been treated by
No,
doctor.
who treated you in Negrims?
Yes,
who-
my lord.
You went to Negrims on your own or referred by the department, by the commandant?
No, my lord, I was treated by my own, my lord.
On your own?
Yes, my
That's
lord.
what I'm saying.
But while joining my duties again, my lord, I have been treated by their doctor and advised me to continue the earlier medicines, my lord.
No,
That is, I have
That's
annexed.
right. So there is a finding by the specialist in Negrims regarding your condition. Have you seen it?
No, my lord. Actually, my client, my lord, he submitted to the department. Thereafter, my lord, it was not having with me.
You show it to him. You see it. The question the court wants to know is, you are aggrieved by the inquiry proceedings or only with the quantum of punishment? Are you challenging the inquiry or only with the quantum of punishment?
Quantum of punishment. But, my lord, this paragraph will clear, my lord. if Lordship goes by this provision of Rule 27, my lord, this paragraph, my lord, keeping the principles of natural justice, page 56, my lord,
Hmm.
keeping the principles of natural justice in view, the official was again given the opportunity to defend himself. When asked, the official refused to keep any defense assistant. The official gave his statement and submitted his medical papers and documents in his defense. The official offered a contention that he has been suffering from mental distress, and owing to that, he could not join his duties on time and remain absent since the time of his leave. In earlier occasions, too, the official remained absent since the time of his leave. The official pleaded his guilt during the departmental inquiry on earlier occasion. Since the official is a member of the discipline force, he has committed a serious offense by remaining absent, deserter since the time of his duties. Exhibit 15, 16, 17. My lord, now my humble submission is that, my lord, my document, my lord, exhibit 15, 16, 17, my lord, they have not given any findings, my lord. That is what I am violated. That Rule 27 is violated. What Rule 27 says, my lord? Rule 27 says, my lord, CRPF rules, my lord, Rule 27C 5.
Hmm. 27.
Page 28, my lord.
Yes.
It's the same barrack.
20.
5, my lord.
Huh?
Clause 27, Rule 27,
When
clause
20
C and subclause 5, my lord. Subrule 5.
Sub-rule 5.
If the accused, can I
Yes.
read, my lord? If the accused refuses to cite any witnesses or to produce any evidence in his defense, the proceeding shall be closed for order. That is one part. If he produces any evidence, that is documents, my lord, I have produced, the officer conducting the inquiry shall proceed to record the evidence. If the officer conducting the inquiry considers that the evidence of any witness or any document which the accused wants to produce in his defense is not material to the issue involved in the case, he may refuse to call such witness or to allow such documents to be produced in evidence. But in all such cases, he must briefly record his reasons for considering the evidence inadmissible. Reasons is must, my lord. When all the relevant evidence has been brought on record, the proceedings shall be closed for order. So no reason has been given, my lord. Simply jumping to the conclusion that I have committed a serious offense, my lord. What is the reason, my lord?
What about compliance of sub-rule 2?
At the commencement of the inquiry, Subrule 2, the accused shall be asked to enter a plea of guilty or not guilty.
Was
After which evidence necessary.
Was it done? Was it put to you, that question? Were you given that opportunity?
Yes, my lord. They have given me opportunity, my lord. I am not on any other point, my lord.
No, Rule 2, sub-rule 2.
Subrule 2. At the commencement of the inquiry, the accused shall be asked to enter a plea of guilt or not guilty, guilty or not guilty, after which evidence necessary to establish the charge shall be let in. The evidence shall be material to the charge and may either be oral or documentary. If oral, it shall be direct. It shall be recorded by the officer conducting the inquiry himself in the presence of the accused. The accused shall be allowed to cross-examine the witnesses. Yes, my lord, I have been given opportunity.
Okay. So your arguments would be 27.5 violated.
Yes.
27.5
Yeah.
not followed.
Yes, 27.
27C 5 not followed.
Yes, my lord.
We are noting down your arguments. Tell us your arguments. 27C5
Yes, that is one part.
violated.
Yes, my lord.
This is
That
one.
one part, my lord.
Yes.
Now,
Then
my lord, now they have conclusion, my lord, paragraph 7, that page 56 again. Conclusion of the EO on the basis of the statement of the witness and documents. I was appointed as the inquiry officer by order dated 28/10/2019 of the office of the commandant to prove the charges framed against so. And accordingly, I commenced the departmental inquiry and concluded it as per departmental rules. On meticulous analysis of the inquiry, EO submits his report with regard to the charges framed against so-and-so, by order dated 28/10 to the following effect. Charge number 1, 2, 3, these are charges, my lord. Now, finally, at page 58, my lord,
Hmm.
the charges framed against so-and-so Ranjan Kumar Sinha stand proved. So, my lord, how it is proved, my lord, without considering my document, my lord. I have a genuine illness, my lord. I have submitted document, my lord. No statement, no findings given about. They should have given at least that statement that these are not sufficient, these are doubtful, or something like that. They should have constituted a medical board also, my lord.
Yes.
If my lord, this point, my lord, if lordship is convinced on this point, my lord, so my lord, proceeding is vitiated, my lord. Natural justice is also violated, my lord.
How can natural justice be violated?
My lord, since my lord, my documents were not properly scrutinized and no findings given, my lord. That violation of provision, that is, my lord. And secondly, is there, my lord, in these findings, my lord, entire findings, my lord, presenting officer has no role except giving a brief note, my lord. So that is one part. Two seconds, and third submission is that, my lord, that finding is disproportionate, my lord. In this regard, I am relying 3 citations, my lord. The one citation that is reported in AIR 2018, Supreme Court,
2018.
Supreme Court, 4860, my lord. I will go by, rely on this citation first, my lord. It has detailed discussed, my lord, how presenting officer, whether required or not, how inquiry officer shall conduct the proceeding, my lord. And even it is the provision of 27C that is also here, my lord, quoted, my lord. So, my lord, this, if we go by this ruling, my lord, lordship will.
Yes. Yes.
These appeals have been filed by the Union of
You are
India.
referring to specifically any paragraphs?
The paragraph, my lord, yes, my lord. Paragraph 11, from 11, my lord, if you go by, my lord, that this is the case of this honorable court, my lord. Then thereafter it was referred to Supreme Court. The Guwahati High Court had allowed the writ petition filed by the respondent on the ground that in the disciplinary inquiry, the principle of necessity was violated. High Court found that no presenting officer was appointed and the inquiry officer acted as prosecutor, which violates the principle of natural justice, and the entire inquiry was set aside on the aforesaid ground, with liberty to the respondent to hold a fresh inquiry from the stage of appointing of the presenting officer. All the appeals filed by the Union of India raises almost similar questions of law and facts, and the Learned Counsel for the Union of India has also raised common submission in all the appeals. Learned Counsel for the appellants contends that High Court committed error in setting aside the dismissal order on the ground of non-appointment of presenting officer. It is submitted that Rule 27 of CRPC 1950, which provides for holding of disciplinary inquiry, does not provide for appointment of presenting officer. Appellants have followed the requirement of Rule 27 in holding disciplinary inquiry in consequence with principles of natural justice. Hence, there was no occasion to set aside the dismissal order. It is submitted that the respondents were given full opportunity in the disciplinary inquiry, including serving charge sheet, giving opportunity to cross-examine the witnesses, opportunity to lead evidence, and submit a reply to the inquiry. Learned Counsel for the Appellant submits that Rule 27 does not mandate the appointment of presenting officer to hold disciplinary inquiry. It is further submitted that even if it is assumed that while non-appointing of presenting officer, principle of natural justice have been violated, respondents have to show that what prejudice has been caused due to non-appointment of the presenting officer in the departmental inquiry. No prejudice having been caused to any of the respondents, they were not entitled for grant of relief as has been granted by the High Court. Learned Counsel appearing for the respondent repeated the above submission contents that the High Court has rightly set aside the dismissal removal order of the respondent. In the facts and circumstances of the present case, appointment of presenting officer was necessary to ensure compliance of the principle of natural justice. While having not done, the respondent have been seriously prejudiced. It is submitted that the inquiry officer himself acted as a prosecutor by putting questions to the prosecution witnesses. Inquiry officer having become prosecutor with entire approach towards inquiry was tainted with bias and has rightly been interfered by the High Court. It is submitted that inquiry officer having acted as a prosecutor, no further prejudice needs to be proved. Now, my lord, paragraph 20, my lord.
Yes.
As noted above, there are two principal submissions raised by the Learned Counsel for the Appellant. They are disciplinary inquiry is required to be conducted under Rule 27 of 1955 rules, which does not contemplate appointment of a presenting officer. Hence, the inquiry proceedings are not vitiated by the non-appointment of presenting officer. The disciplinary inquiry has been held against the respondent by complying with the principle of natural justice. No principle of natural justice is violated by non-appointment of presenting officer. No prejudice has been caused to the respondents by non-appointment of presenting officer. Paragraph 21. Rule 27, sub-rule C of the CRPF rules 1958 provides for the procedure for conducting departmental inquiry, which is as follows. This entire proceeding is quoted, including our provision 5 is also quoted, my lord. Then paragraph 22, my lord. A perusal of the aforesaid rule does not indicate that rule contemplates appointment of presenting officer. Service conditions, including punishment and appeal procedure of an employee, are governed by statutory rules. CRPF Act 1949 has been enacted by the Parliament for the constitution and regulation of an armed central reserve force, police force. Section 18 of the Act empowers the central government to make rules for carrying out the purpose of this Act.
Yes, yes, all right, all right. Yes, respondents?
Now, kindly come to the order passed, Lordship. Page number 67, Lordship. And then come to Lordship 71, Lordship, the relevant, but the other charges were framed. Well, start. May I read, Lordship, page 71, writ petition. While starting the departmental inquiry on so-and-so, the charge official appeared before the EO and EO has first read over the charges framed under this official to him, copy of which was earlier furnished to him. On so-and-so, EO recorded the statement of the official and asked him whether he had any objection regarding to the appointment of the EO, whether he received the charge sheet, whether he understood the charges point-wise, in which language the intended the inquiry to be conducted, and whether he would keep any defense assistant for his defense. The charge official replied the question and put his signature. The EO asked the official whether he pleaded guilty to the charges framed against him, whereupon
No,
the
his
official
case is that the presenting officer,
acted as a
no,
inquiry officer.
inquiry officer acted as a presenting
presenting
officer,
officer.
notwithstanding a presenting officer had
Sorry.
already been appointed.
Lordship.
There was hardly
But-
any role for the presenting
Lordship.
officer.
But from the record, Lordship, I have seen, Lordship,
Hmm.
the presenting officer played the role, Lordship.
All right.
Yeah.
Then,
Lordship, then paragraph 4. While continuing with the inquiry recorded the statement of the evidence in presence of the against force so-and-so and allowed the official to cross-examine each and every witnesses, but the official refused to cross-examine the witnesses. The EO furnished copies of the statement of every witnesses to the official and the later put his signature of acknowledgement of the receipt. The EO completed the inquiry with honesty and impartial way by and within the parameters, rules and norms. In the course of inquiry, the EO gave ample opportunity to the official to produce evidence documents in his defense at the every stage of the inquiry. After concluding the inquiry officer submitted the report to the undersigned by letter dated so and so, wherein the inquiry officer found the charges framed against him, the officials are proved. As per report of the EO and the statement of the witnesses and the document, casual leave for 15 days for so and so to so and so, including the Sundays on so and so to so and so, and 31 was granted to the force so and so. CRPF, and accordingly he was supposed to report to TC Jammu on so and so while traveling in night, but the official remained absent continuously from so and so without obtaining any permission from the competent officer, and reported the battalion on so and so at 4/9/2019 after remaining absent for 155 days, that is from 3/4/2019 to 4/9/2019. The company commander so and so while later dated so and so and so of his office directed him to join his duty immediately, but the official neither joined his duty nor gave any information. Thereafter, warrant of arrest of the official was issued by later dated so of his office and sent to the concerned superintendent of police, but the official did not join his duty, nor he could be arrested by the police. After voluntarily remaining absent for 155 days from so and so date, from his leave without obtaining permission from the competent officer, the official reported to the battalion on so and so date. The official neither replied to the letter sent to him by the office nor joined his duties, which shows his deficient negligence to the order given by the higher officer. In addition to that, as per the inquiry report, the official is a habitual to the remaining absent repeatedly since the time of his leave. Thereafter, before passing the final order on the report of the inquiry, the competent authority by letter dated so and so furnished a copy of the inquiry report to the official with an instruction that he intended to submit any document represented against the inquiry report in his defense. He should submit the same within 15 days. The official received this letter on 2/1/2020, but he did not produce any evidence on witnesses. After careful and meticulous perusal of the inquiry report in the light of the rules and order required, I undersigned have come to the conclusion that the inquiry was conducted as per principles and was given proper opportunity to defend himself at every stage of the inquiry. To so and so, after remaining absent for 155 days from so and so, since time of since his leave without obtaining permission from any competent officer, thus he committed an act of gross indiscipline by remaining absent since the time of his leave. Without the permission of competent authority, he neglected the orders given by the higher officer of his battalion. Furthermore, it has been found in the service book of the earlier occasion too, he remained absent from the duties since his leave. His absence since leave is as follows, Lordship.
What is the
That-
punishment prescribed for leave, unauthorized leave?
Lordship, dismissal, removal from services are there, Lordship.
Where is it there?
Lordship.
Rule.
Section 9, offences and punishment, Lordship. These here absent himself without leave or without sufficient cause overstays leave, he may be shall be punished.
Close.
Lordship, it come to
Clause?
section, Lordship, it will come to section 10 M.
Section 10.
M.
This is less heinous offenses.
Lordship.
Ah.
Absent him with leave or without
This is with
sufficient-
imprisonment.
Lordship, but there is disobey the lawful command of a superior officer was also there, Lord.
Huh?
That section 9E, disobey the lawful command of a superior officer was also there.
Section 9
9E.
E.
While on active duty. He was not on active duty, my lord.
But see the punishment for that. Where is it? Where is removal prescribed?
Really, there, Lord.
My lord, 10 M, my lord. Absents himself without leave or without sufficient cause overstays leave granted to him. Shall be punishable with imprisonment for a term which may extend to 1 year or fine which may extend to 3 months.
Yes, Mr. Roy.
Is there lordship, removal is, yes, lordship.
Yes.
Lordship. And it kindly, there is lordship.
Where is it? Where is it?
Lordship, section 11, lordship, minor punishments may come back. The commandant or any other authority or officer as may be prescribed may subject to any rules made under this act, award in lieu of, in addition to suspension or dismissal, any one or more of the following punishment to be the member of the force whom he considered to be guilty of disobedience, neglect of duty or remission in discharge of any duty or other misconduct in his capacity as a member of the force. This order has been passed under 11(1), lordship. The commandment.
11(1).
Yes.
11(1) talks about reduction.
Commandant or any other authority
In addition.
subject to in addition to suspension or dismissal or any one or more of the punishment to any member of the following. The order was passed under section 11(1) and rule 27 of the CRPF.
Yes.
My lord. In a similar situation, my lord, a question arose before Honorable Apex Court, my lord, that whether major punishment can be given under section 11(1) or not, my lord. Because, my lord, less heinous and more heinous, these definitions are given, my lord. So in that case, my lord, what happened? Constable was given due to his unauthorized absence. He was removed from service.
Giriraj.
Yes, my lord, removed from service.
You are
thereafter-
relying on Giriraj Sharma.
Yes, Union of India versus Diler Singh.
Acha.
But what I am going to say that, my lord, authorities can exercise power under section 11, my lord, removing, my lord. That removal power that is clarified by Honorable Apex Court. In that case, my lord, civil court title suit was filed, my lord, challenging his removal, my lord.
Hmm.
And thereafter matter reached to Apex Court, my lord. Apex Court has clarified that, my lord.
What is the citation?
Yes, sir.
Citation of
2016 13 SCC 71.
Party name? Name of the parties?
2016 13 SCC
Party.
71.
party name.
Party name Union of India versus Diler Singh, DILER
DI
Singh, DILER
LEI.
LER Diler.
Okay. Any paragraphs?
Paragraphs, my lord, I have not gone through in details, my lord, but it was in my file, my lord.
All right. All right. All right. Okay. That's all.
It may help lordship, my lord, coming to right.
We don't know if it
For
helps. It is for
non-cons-
you to tell us whether it helps or not.
Further lordship, during non-consideration of his medical paper, page 87 may finally be seen. There is a consideration of his medical papers. Appellate order, lordship. If
In the
80
appellate order.
Yes, in 88, page 88, paragraph 6. It has been considered, lordship.
Isn't there a office memorandum or notification for rehabilitation of soldiers who are in the lower medical category? Is it under CRPF or Assam Rifles? I forgot.
I have to check it up, lordship. In the appellate order, lordship, it has been considered with medical papers.
This is at the appellate stage, my lord.
It has been
Inquiry
considered.
officer and
It has
departmental
considered.
impugned findings, my lord, did not discuss about these documents, my lord. At the appellate stage, my lord, appellate order is simply stating that these documents cannot be considered as sufficient basis. That is the only.
Yes. All right.
Regarding habitual offender, recently coordinate benches has passed an order, lordship, in WPC 1155 of 2011 regarding habitual offender and unauthorized absence. recently passed lordship this judgment by the coordinate bench.
All right.
Two other citations, what I am relying, my lord, just simply summary that. my
You,
lord.
you give us a list. You give us the list.
I have supplied already.
You supply the list. They heard the
Lordship records were
we'll have to retain it
lordship.
unless you want to give us some photocopies or something.
Lordship then may keep this record.
Huh?
And Lordship can keep this record.
We'll keep it.
Of like,
Thank you. Finding. May I pleases your lordship, on behalf of P Nayak, your lordship, he is on the legs, your lordship. Kindly pass over the matter for time being.
Yes, Mr. Chetri.
Probably if we start, then he may come.
That will
As-
take time, your lordship. So your lordship, kindly pass over the matter for time being, your lordship.
What we will take up at 2.
Oh.
If not,
Yes. What is the matter about?
Lord, that promotion, man,
Oh,
of senior administrative assistant, man, last time lordships heard the matter because this petitioner.
that degree, BA,
Yes.
BA.
Yes. The Harshindi, they passed Harshindi, they became eligible for the post of superintendent. Now, when they were expected to be considered the promotion, for the post of superintendent, abruptly one rule has come. In place.
We have to challenge that rule.
Rule is, only there is a provisions of relaxation, under this provisions I have come. Had there been that rule.
Who is supposed to consider that? Relaxation?
Consider, since this our High Court has also considered that aspect, that since
So have you applied before the authorities
yes,
for relaxation?
yes,
Have they passed any order?
in earlier occasion it was there, subsequently I have again submitted representation that that is pending.
You
He will be coming, your
you
lordship.
get your instructions from him. Find out if it can be closed by remanding it to the department to reconsider. That is what they'll do.
Yes, and since in lordship will find.
No, your prayer is only for relaxation.
Relaxation.
So relaxation is to be given, if at all, by the departmental authorities.
Yes,
Now, if the departmental authorities, you have filed some representation.
yes.
So that has not been disposed of.
In earlier occasion, 3 representations were filed by the earlier this petitioner,
Mr. Chetri,
lordship.
if you are questioning that you have a vested right to be considered
Yes,
for those vacancies which were available prior to the rule being amended,
Yes.
then this matter will have to be heard on a different, on those arguments, which prima facie, I don't think you have any vested right, strictly speaking, in view of the judgments of the apex court. So if your prayer is only limited to the issue that matter is pending before the authorities and they have not considered your application for relaxation, Then we can close it on that point.
Yes, sir, that can be done, my lord. And my lord, to that effect, my lord, that representation is pending as on that, my lord. And to that effect, my lord, in earlier occasion also, this petitioners submitted representation, my lord. And that accordingly, these petitioners came before this honorable court. This is second round of litigation. Then, my lord, the direction was given by this honorable court just to dispose of the representation. My lord, accordingly, they dispose of the representation. Subsequently, again, I have submitted representation by relying all these rules, my lord. Rule 16, my lord. In earlier occasion, the rules 16 was not relied, just the representation was submitted. And subsequently, this by relying the rules, which was in the new rules also, my lord, regarding relaxation, that has been carefully taken care of, and accordingly it was submitted. That is pending, my lord. And this in most of the judgment, I have also gone through, my lord, of this honorable court, my lord, where this honorable court has that though in earlier occasion the government has rejected the claim of the petitioner, but otherwise it was directed the government to consider his representation and to promote the persons, though his degree, which was recorded as B.Ed, may not be necessary. That point, my lord, already been this honorable court has decided by single bench itself.
B.Ed.
B.Ed. Here in one case, my lord, B.Ed was necessary, was required. Lordship will find, my lord, some of the decisions I have, my lord. This
2020.
2020.
What was the issue there?
Here, my lord, here also regarding relaxation of essential qualification. Para 13. Para 13, 14.
Essential. Referring judgment. 2020.
Lordship will have a look at para 13, Lordship.
Let us first understand what were the prayers here. Come to para 3.
Yes, ma'am. The petitioner is also claiming double promotion to the post of additional director from the post of deputy director, which she is holding on regular basis. However, the only hurdle before the petitioner is the stipulation of possession of B.Ed degree by the incumbents before being considered for double promotion, which degree of the petitioner does not possess. The case of the petitioner is that the requirement of B.Ed degree is nowhere mentioned in the relevant recruitment rules. It is all.
Let us wait there. B.Ed was not mentioned as a requirement in the relevant recruitment rule.
It has, yes. It has been submitted that the recruitment rules were framed by the state government, namely Assam Educational Research and Service Order 2007, which were notified on 4/12/17. Order 12 of the aforesaid Order of 2017 provides for recruitment by way of promotion, in which it has been provided that the post of additional director SCRT will be filled by way of promotion from the post of joint director having requisite qualification as regular service as prescribed in the Schedule 2, and the candidate has to be possess training on teacher education as career progression. It has been submitted. If one refers to Schedule 2 of the order mentioned above, there is no reference to the qualification required for promotion to the post of additional director. Schedule 2, in fact, it deals with qualification and experience prescribed for direct recruitment for the post of assistant director in the rank of assistant professor, lecturer, SCRT, etc. mentioned therein. It has been submitted that Schedule 2 nowhere speaks of the qualification required for promotion to the post of additional director. It is accordingly submitted by the learned counsel for the petition that if the rules framed under Article 309 of the Constitution are silent on the requirement of position of B.Ed degree for promotion to the post of additional director, it will be impermissible for the government to issue an order without having any reference to Article 309 of the Constitution for adding a qualification for promotion. It has been submitted that the aforesaid order 2017 were framed by the state government in exercise of the powers conferred by Article 309 of the Constitution of India. Thus, it is legislative in nature, though delegated. On the other hand, the order dated 5/12/2017 is merely an executive order without having the force of delegated legislation under Article 309 of the Constitution of India. It is in that context that it has been submitted by the learned counsel for the petition that this
Here
insistence.
the rules are amended, isn't it? In your case,
309.
your rules are amended.
1309 is there. There the requirement was not there.
Uh.
By subsequent passing an executive order, the requirement was fixed, Lordship. That is why court said if it is not there in the 309, by passing an executive order, you cannot add another qualification. That is
And-
the
This is, my lord,
No, his grievance is that, see, they were people who were working earlier. They did not have, that time there was no requirement of graduation. Subsequently, it was amended saying that for next higher post, you must have this higher degree.
Yeah.
Now they want to urge before the authorities that having rendered so many years of services, kindly relax this requirement of higher education and consider a case for promotion.
But in earlier round, Lordship, court directed, go to the authority will pass a speaking order. Authority has passed an order, Lordship. Now against that order, they are before this honorable court.
Which is that order?
Last page. Now, Lordship,
Lordship will find at
consider that,
best-
Lordship, if it is not tenable, Lordship will set aside, and if it is not, Lordship will,
Which is that order?
at page 100, Lord.
You're in which category?
Lordship.
No, in the page number 100, where are the petitioners? Are they
Lordship, it's,
reflected?
in the second middle portion, Lordship,
That is,
read petition 5376 2021 at serial number 3, Lord.
okay, order dated 6/10, 6/10/21.
Yes, Lord. 6/10/2021.
although the provisions of Rule 16 stipulates that the government has the power to relax the provision of the state rule, it is an exception rather than the rule. If such relaxation was to be given in each of every case, the very purpose of enacting the new rules shall be repeated accordingly. No, my lord, here other
Where was the order of the court earlier?
lordship will find at page,
It starts from 86, Lordship.
86. No, in respect of the writ petitioners,
yes, my lord. In respect to the petition, my lord, 73, my lord.
73.
Start from 73.
73.
Lord.
This is your writ petition
Yes.
earlier.
Yeah.
So what was the finding of the court?
Finding of the court is this, my lord, for some pages is left. Lordship will Lordship will find the finding, my lord, at page 85, my lord, 84 and 85. Last para, 7, my lord, 84. Be that
84,
as it may,
84.
84, my lord.
You said 73 is
No,
your
73, my lord, the last para is somewhere the
77.
84 is also the order of this honorable court. Same order.
We are concerned with the orders passed in your case.
My lord, same, this is also my case. This is also there. 84 lordship, kindly have a look. Same order. Three repetitions, my lord, same cases, same order.
Yes. Then
84, my lord.
paragraph
Paragraph 7.
7.
Be that as it may, having taken note of the case as projected by the petitioner that the Assam Secretariat Service Rules 2019 contains provisions for relaxation of rules without examining the merit of the claim and without adjudication of the matter. The court is of the considered opinion that the ends of justice would be met if the petition is disposed of at this motion stage by directing the Chief Secretary to the Government of Assam, Respondent number 1, who is the competent authority under Rule 2A, sub-rule clause 2 of the Assam Secretary Service Rule 2019.
And where is your representation?
Representations are there. The earlier representation.
Earlier.
Earlier representations are, earlier representation starts from page 66. Uh, 66 to 70.
Representation kind of sign card. Second. নালাগে কোর্টৰ ডাইৰেকশ্যন মতে ফোন কৰিছো কেইটা ইয়াত ধীৰেন্দ্ৰ পাটৰে
The court directed that representation should be disposed of. And it was disposed of. And where is the impugned order again? 100?
100 law.
100. So the impugned order disposed of, but without considering the issue which they wanted
Yes.
in their representations to be considered.
Basically,
The
lordship, whether-
impugned order, if you look into it, is that no candidate without required qualification, that is graduation, has been considered. That is what they decided. What the petitioners represented was that as a one-time measure or something, our case should be considered.
That's
That was not done. So
for one-time lordship, that relaxation is the criteria law.
that's what. So
And
on
here
in
the
that
authority has
context,
decided that it cannot be relaxed.
no, they did not consider it.
Lordship may kindly see page 102, lordship,
102.
paragraph, third paragraph.
Yes.
although the provision of Rule 16 stipulates that the government has the power to relax the provisions of the said rule, it is an exception rather than the rule. If such relaxation must be given in each and every case, the very purpose of enacting the new rules shall be defeated. Accordingly, the provisions of Rule 16 are to be used cautiously and not at all the time. Lordship, my basic submission will be, Lordship, this Rule 16 is basically a discretion, Lord.
So quite right.
It is
But
just a law.
discretion will have to be exercised because it is a rule. It is a rule. It is a part of the rule.
Yes.
Now, for what purposes is the rule there, if not for applying it? The question is, in what cases will you apply it?
Lordship, some cases are there like, so far as this case is concerned, Lordship, educational qualification is the substantive criteria, Lord. That cannot be relaxed. In some cases, Lordship, that can be relaxed, Lordship. It has been relaxed also earlier, but not in cases like this. Lord.
How many persons are there?
In this case, Lordship,
Now,
16 there,
16 out of
17.
17, my lord. 2 persons already been retired and 2 persons already got relief. And now only 13% remain, my lord.
Lordship, what I am submitting,
And others
Lordship,
are going to be retired, my lord.
this case will require some time, Lordship. I have some judgments also, Lord. Other judgments are, recent judgments.
No, we are not trying to give a finding as to how and where, in what circumstances relaxation is to be used. We are trying to understand whether in terms of the court's order read with the representation file, whether the matter was considered.
Lord.
Yes, there is a reference that Rule 16
Yes,
is not a case to be applied in each and every purpose. Now, only question is whether their services rendered is required to be taken note of, or is it a case that there are sufficient number of person with the requisite qualification of BA, for instance. Let us say, hypothetically, let us say that the number of vacancies are more, but persons with BA as on date are not sufficient to fill up all the posts.
in those situations, Lordship, yes, possible, Lordship. Suppose there are no
So all
sufficient number of
these
candidates,
findings on facts will have to be considered by the authority ordinarily. More
One thing
particularly,
is clear, Lordship, as on date, no vacancy is there and eligible persons are there.
Now, we are also eligible because 5 years experience is there.
so
that-
then we'll have to hear it on the ground if the matter has to be urged on the point of whether essential qualifications can be relaxed or not. Then we'll have to hear the
On
matter.
that point only, Lordship,
that
There is no quarrel that
Yeah.
ordinarily it cannot be relaxed.
no,
There's no
here,
quarrel.
in division bench of this Honorable High Court, Lordship, kindly have a look at second judgment, my lord, I have referred. 2021 3 GLP.
See,
my lord.
binding effect is with regard to a
Only-
ratio.
Yes, only we
The
are.
ratio will have to be such that it is binding.
And here, my lord, this division bench, though in the division bench, this case was filed challenging the rules, but para 6, it has been said that he is not challenging the rules. Subsequently, he has come back and submitted before the Honorable Court that only under the Rule 8 of 2003, his case may be considered. And accordingly, exactly in similar circumstances, my lord, para 10 onwards, my lord, the higher qualification was prescribed by way of inserting new rules, my lord, 2013 rules here also. Here, my lord, this Honorable Court, after going through all this, this fact and this grievances of the petitioner, it was directed to the authorities concerned to consider his grievances in respect of relaxation of his degree, my lord, qualification.
Lordship, that is a different issue because that at that point of time, Lordship, Rangaya judgment was prevailing. And court directed,
No, no.
if vacancies are there, Lordship, prior to amendment of the rule, then they may be considered for those.
That
posts.
position has changed.
That has changed now. Lord.
Now, Now,
When during the time of the division bench judgment?
this division bench.
No, division bench is post Rangaya.
Yes.
Division bench judgment is post Rangaya.
21.
2/3/2021.
No, Lordship, judgment I am referring to, Lordship,
Hmm.
is of 2023 judgment, Lord.
Hmm.
2022 judgment, Lordship. It's State of Himachal versus Rajkumar, Lord.
Hmm.
That Rangaya judgment was overruled by this, specifically overruled.
Only
That was in 23,
2022, Lord.
22.
Yes.
No, even after that, even prior to that, there is this Dinesh Agarwal or some judgment where the Supreme Court held that the vacancies which were there prior to amendment,
That
there is
may
no
be filled up
universal proposition
yes,
that it has to be filled up.
without pressing for the
Ah.
additional qualification. But it's a 2022 judgment, Lordship.
Okay.
May 2022. So Lordship will take up this matter, Lordship, on a
Okay, then we'll have to hear it on this line.
no only short and very specific the prayer of the petitioners are there, my lord. Since in other occasion, this honorable court disposed of the matter, only directing the respondents to consider the.
No, let us
to
not,
dispose of the
that kind of an order is not going to benefit you.
Yes.
We'll have to find out whether, what is the interpretation of relaxation of a rule vis-a-vis the petitioners. So
And-
we will require hearing.
And three judges, this 19.
Give us a date, we'll take it up.
1990, my lord.
Yes, we'll take it up, Yes, heard
1990.
learned counsels for the
Three
party.
judges, my lord.
We'll take it up for hearing then. We'll take it up for hearing.
When, lord?
Give us a date,
Short date, my lord. Otherwise,
a
person
very
will
short
be-
date. Tell us.
Person will be retired, my lord. Other not. Everything will be in talks.
28 September,
Lordship.
28 September. All right. 28 September for hearing,
For admission, yeah.
admission hearing.
Obliged.
May it pleases you, Lordship. SMT 60, Your Lordship, he is on the legs, Your Lordship. Although, Your Lordship.
What is
appeal-
the issue about?
Well, there is a judgment that has not been complied with. That is almost 5 years elapsed. Page 13 is a relevant portion of the judgment, 22/1/2019. As per the judgment order, the services of petitioner is required to be regular in terms of the 2011 Act, Provincialization Act. So,
Why it has not been any appeal, any review?
Yes, Your Lordship. Appeal has been filed against it, Your Lordship, which
Stay?
will be. Yes, Your Lordship.
Any stay?
No, Your Lordship. Appeal cannot be listed, Your Lordship, as Your Lordship, Chief Justice, Your Lordship, DB constituted, Honorable Chief Justice has taken up a provincialization matter. For that, Your Lordship, special DB has been, Your Lordship, will sit, Your Lordship, and that matter has not been listed, Your Lordship.
We are not
Because-
concerned with your issues. This is an order. He has come back.
Already appeal
There
has
is a
been filed,
direction.
Your Lordship, on dated 14/9/23, Your Lordship.
There is a direction to comply with this order. This direction does not contain that in case you file an appeal and the appeal is not listed, compliance of the order is not required. It's not the finding.
Appeal has been filed, Your Lordship.
Maybe, but is there a stay of this order?
Your Lordship, SMT 60, he will be appearing in this case, Your Lordship. So, Your Lordship,
may I draw your lordship's attention, order dated 17/5/2023, your lordship's order. SMC 60 was directed 2 weeks time. Then again it was listed on 11/8/2023. Again similar, same position. The other day he was not
present. while
Where is,
matter
where
was
is Mr.
called on-
Chisti?
He's on the legs, your lordship. He will be coming, your lordship. So can you pass over the matter for time being, as
At
he is
2,
on,
at 2.
my lord.
deeply obliged.
Yes. Yes, madam.
Yes. My senior.
What is the issue about?
Lordship, petitioner was a petitioner is the employee of IOCL, and his 3 increments were stopped.
Hmm.
Actually, the petitioner applied for the for promotion of grade A officer, but his application was rejected
Hmm.
on the basis that he is not like, he is not qualified for that post.
Yes. Yes.
Grade A officer under Fire and Safety Department.
Hmm.
But when the petitioner inquired about the matter in the department, but they issued a letter that he is applicable for he is qualified for the post, and that is letter dated 23/3/2017. We find additional affidavit with additional affidavit dated 29/3/2018.
Additional affidavit?
Yes, that letter was tagged.
Yes, Mr. Deka, why have you stopped the increments?
Increments? No, my lord, hearing this,
Ah.
sorry, my lord.
Yes, yes. Sorry, we didn't notice you. Yes.
Sorry, my lord. In fact, it is denial of to appear in the interview for promotion. My lord, what happened? The
Hmm.
petitioner, he is an senior engineering assistant, grade 8 post, my lord. And he got the promotion in 1/7/2007. A circular was issued on 23/5/2012 and page 27. Has your lordship got it?
Page 27.
Yes, my lord.
Yes.
By this circular, my lord, application are invited through proportional from eligible workmen in grade 7, 8, 9, meeting the following criteria for the post of officer in grade A in following discipline: fire and safety. I am
You are in the fire and safety.
safety.
All right. Then
Now-
what are the conditions?
Condition number 1, the applicant should have completed minimum of 4 years service in grade 2,
Grade 7.
grade 8, grade 7 and grade 8 as applicable as on 30/6/2012. I meet the criteria.
Then
Then, my lord, I applied for it, but they did not call me for interview. And therefore, I approached this honorable court.
okay.
Now they file an affidavit which is then that they did not call me because I am in single cadre post so and so as per memorandum of settlement.
Hmm.
Yes, therefore, I am not eligible to the post of officer grade A.
And according to the memorandum of settlement, what are the terms?
That your lordship at page memorandum of settlement is start from my lord in the affidavit, my lord, at page 11.
Yes.
If your lordship go straightway take up the at page 16, my lord, internal page.
Hmm.
Has your lordship got it?
1/6.
1/6 internal page.
Yes. Yes.
Clause 5 down below. Has your lordship got it?
Yes.
Promotion from non-officers to officers category. Promotion to from non-officers to officer category to the officer category group, officer grade A, under the existing 50-50 promotion policy, wherever such policy is applicable, will be on the basis of net outgo on officers in grade A by way of normal attrition, that is promotion, resignation, subordination, date, etc., plus any creation of post. Such promotion will be affected against available vacancy as per norm mentioned in Annexure 2. The promotion will be affected once in a year in the month of July. This is the only condition for promotion from non-officers to officers grade A. Yes, single cadre post, nothing, my lord, no mention, my lord. If the Annexure 2 is at page 21, your lordship will find that Annexure 2 also. That laid down the criteria of the marks to be given.
Hmm.
So, my lord, I have completed 4 years service, my lord, on the day of application. As per policy, my lord, I am entitled to get settlement. As per settlement, my lord, I am eligible to appear in the interview, but they denied it. Now, even after filing affidavit, then the additional affidavit I have annexed. Now they said that no, you are eligible. I am eligible.
Now they say you are eligible.
Now they said, my lord, in my additional affidavit which I filed on 29/3/2018, my lord, I have annexed a document, my lord. As your lordship later, my lord.
Page 101, ma'am.
101. Yes.
Lord, that letter at 23/3/2017, Chief Human Resource Manager, the person who, the officer who, where the affidavit here is, affidavit of what is it? The officer is defined, but the
This is in
Oh.
2017.
17 letter.
Then
My case is of 12, my lord, 2012.
yes, what do you say?
Lordship, in 2012, my lord, the memorandum of settlement which was in operation, my lord, their single cadre posts were not entitled to be promoted to officer level. So in 2017,
Where do you say that from?
that page 16 itself, my lord,
Page
what my learned
16.
friend has just now read, my lord, just above that page
Page 16.
Internal page 16, 43, I think, my lord. Continuous running page is 43.
16 of the affidavit.
Affidavit. 43 is the running page.
43. Yes, single cadre.
4.4.
Yes.
Employees who are in the single cadre positions as mentioned in annexure 3. I'll come to annexure 3, my lord. Will receive promotions within the cluster as per the policy for promotions within the cluster mentioned in item 2 above.
So where is that 3?
3 at page, internal page 25, my lord, 52. At the bottom, my lord, safety inspector.
52. Single
52.
cadre.
Single cadre positions.
Cluster C.
Cluster C, safety inspector. He is a safety inspector.
Hmm.
So he is entitled to promotion only within the cluster.
Where?
Where?
What is the next higher promote post?
He will not get it, my lord. He'll only get pay.
Huh?
He will only get pay.
Pay of what?
Increment, my lord.
Huh?
Pay increment, my lord.
No, but you said he'll be promoted.
No, he'll not be promoted. He'll be
Yes.
promoted within the cluster. That is the highest in the cluster. Cluster C is the highest in the cluster. So he has got promotions from cluster A, B, and A, B to cluster C.
Hmm.
C is the highest. From C, the promotion is to officer level.
Ah.
Because this is not a policy, my lord. This is a memorandum of understanding between the workman
This
and
is
the
a
management.
memorandum of understanding which is very lopsided towards the management.
No, my lord, cannot be, my lord.
Absolutely.
It is
What is this?
before, it is in front of the conciliation officer.
What is this? You are making us,
Lordship will
you
kindly
are
come
saying
to
that
page
these
38, my lord.
people are to be promoted and then you say that you can't be promoted. You'll only get your salary.
That has to be put to challenge, my lord. It is an agreement. I do not make it, my lord.
No, of course
It
you
is an
don't make
agreement.
it, but
The management does not make it, my lord.
who
The
has made
actual
it?
thing starts at page 53, my lord.
Who has made it?
It is
It
a
is
memorandum of
memorandum-
settlement arrived at between the management
Correct. So why do you say
Management-
the management has not made it? You have given
and
me
their workmen. It is a memorandum of settlement arrived at between the
Workmen-
management of IOCL
Work-
and their workmen, represented by the
workmen is
union.
all right, but management knows, management is aware of what, who is supposed to be
also knows, my lord.
promoted, where to be promoted.
Workmen also knows, my lord.
Now, on what basis have you now decided to promote him
My
from
lord, maybe there is a
2017?
change in policy, but I was coming to that, my lord.
Hmm.
Now, this particular affidavit, my lord, was not served upon me. Only on the last date I have come to know about this affidavit.
Which affidavit?
This affidavit, additional affidavit, page 99, my lord.
Probably, my lord, kindly,
This was not served upon me. I have
to
sought
my-
for
to
instructions, my
my-
lord.
To my information, my lord, that was served.
No, my lord, it was not served, my lord. Someone's signature is there. I have checked the notice. Anyway, my lord, I have sought for instructions as to was there any change in policy in 2017?
Then what have they said?
I have not come back with anything, my lord. Because now what is the position where the petitioner is, my lord? I have no instructions, my lord.
No, but you have to seek instructions whether the gentleman was in office when he signed this. If he has signed this, where is the question of policy, no policy?
Which
The department has agreed, chief human resource manager.
exactly, my lord. This is the policy. Lordship will kindly read the letter.
Ah,
With reference to your letter dated 16/3/2017.
hmm.
On the above subject, this is to inform you that as per promotion policy of non-officers applicable as on date, my lord.
Hmm.
So as on date is 2017. So the
Right.
policy I am referring to is of 1992, my lord.
And then when was the next policy?
That's what I have to take instructions, my lord, because the amendment
What
which
is
I have
this?
annexed
What
is
is
the
this?
last is of 2012, my lord.
What is the policy at page 74?
Page-
Sorry, memorandum. Page 74.
Page 74 is dated, my lord.
Okay. I think we have to rise by the clock.
It is 96, my lord.
96.
And the latest one is at page 83, my lord.
Yes,
It is of
Mr.
2001.
Kotoki, what do you? He says he's waiting for instructions, or you want to take it up? at
Hello.
two?
Thing is this, it is a promotion to the post from non-officer to the officer cadre. It's covered by clause 5, not from by the 4. It is, my lord, that's the difference. He is relying on 4 among the cluster.
Let him get his instructions he has sought for. We'll give a short date.
Because
No, let it be next, any day next week. my lord.
Next week? Next,
Because he might have been promoted from 2017.
next week, Mr. N. Deka, Learned Standing Council, IOCL, prays for and is granted 1 week's time to obtain instructions on the affidavit. What is this additional affidavit
Additional.
filed on 29 March 2018 by the petitioner, which Mr. Deka submits he did not receive it.
I did not. I
Did not receive it. Be that as it may. His instructions be placed before the court on 28 September,
26th also maybe.
Hmm?
26th.
26th, all right. But that will not be 1 week.
We are 19. On the 28th or 28th, another matter is fixed. That's why I'm. Can it be on 27th or 29th?
All right, 29th,
29th.
29th. Mr. Kotogi,
Yes,
29th. Mr. S. Kotogi appears for the petition. Why should we give you that liberty? Why are you mentioning now? You're not supposed to mention.
Lordship, actually at that time I was in different court, Lordship.
Whatever if you have missed out, you have missed out. There is a provision for circulation of adjournment slips. Are you not aware? You should fill it up and circulate, send an email. Is good enough. Follow it. Yes, item.
Item 20, for the petitioner, I have been terminated and
If you are in urgency, don't agree to the adjournment.
the council called up the petitioner from the they will in the morning, but it's not mentioned. I'm ready with the case, but the petitioner by so I prayed two other officers.
State Bank of India.
Two other officers based on same charges, identical charges, they were given a very lesser penalty. I have been dismissed from the.
All right, we are taking it up. Let it be listed next week then.
24.
We don't know the date. Date he'll give you. Next week. Next week I've opened a date. Give it on a miscellaneous day. 29. Yes. Right. Yes. 13.
13.
Yes.
Here the issue is, Lordship, now the petitioner is trying to regularize the period of discontinuation, Lordship. Here initially he was discontinued from service. Prior to that, Lordship, the fact of the case is that petitioner is an ex-army man. And ex-army man, where there was a scheme issued by the government of India that is called PIF scheme, Lordship. That PIF is for prevention of infiltration of foreigners, Lordship. It was
Prevention of?
infiltration of foreigners from it was specifically for introduced for Assam, Lordship. And in that scheme, Lordship, the ex-soldiers, ex-army men were, Lordship, they were appointed and on ad hoc basis. Lordship. It was in the year 1960 it was introduced, and it's still continuing.
Oh, what is that order you're referring to? Some writ petition order?
Yes, Lordship. Lordship, that will clarify everything, Lordship. That petition order is at page, Lordship, which was passed in terms of the Honorable Supreme Court judgment. Page 35. Start from 35.
Hmm.
The facts also given there. Let's start from page 38.
You mean to say that this is covered?
Yes, Lordship. This has been passed, Lordship, in terms of the Honorable Supreme Court judgment, which I have annexed here, Lordship. So, Lordship, if we read everything, the facts is clearly written in both the judgments, Lordship. May I read, Lordship? Page 38.
Yes.
Page 38.
No, you tell us if you agree that this is a similar matter, then
No, I am not on requisite. To which has been already my service was discontinued as in terms of the agreement by which I was appointed. But subsequently by this order, Lordship, that discontinuation has been set aside. And I have been, Lordship, reinstated.
But that gap period between the reinstatement and the lordship discontinuation, that has been not been continued. Though they are the
Not been regularized.
not regularized. Though lordship, there the honorable governor also lordship says that though it was a scheme, in terms of the honorable Supreme Court order, they are entitled for pension, etc. And in item number 14, lordship, next item, lordship had last occasion, lordship had asked for the some records from the department, lordship, wherein it was stated that whether he has received pension or not. And I have come to know that he is receiving pension. That item number 14. Same issue, his name is also there. But here, lordship, due to non-regularization of that period, in spite of the honorable court's order and the honorable.
Where is your appointment order?
Yes, sir. My appointment order is at it is at page 27. It is an ad hoc basis.
Temporary appointment,
Yes, temporary.
monthly salary.
Yes, lordship. That was, lordship, that was set aside by the honorable Supreme Court, which is there. I have an answer. Because a set of people, they approached the Supreme Court regarding that against this lordship, that conditions.
Hmm.
Because the PIF scheme, though it's a scheme, lordship, still it is continuing. Honorable Supreme Court said that since it is continuing and the people are the persons employed appointed under this scheme are giving doing the similar duty, so that should not be there, lordship. And that justification is at page, lordship, of the honorable Supreme Court order, lordship. At page 51, the justification why it is required to be continued. And in terms of this order, lordship, governor has issued that they are entitled at page, that may be also, lordship, the order of the honorable governor, lordship. We are not on, lordship, that area salary. Page 70 is the honorable government order, that is honorable Supreme Court order has also been reflected here. 70.
Seven zero.
70. May I read?
Yes.
Lordship, it's a order dated 23rd September 2011. Lordship.
Hmm.
Orders of the by the governor. Whereas the Honorable Supreme Court of India in civil appeal number so and so arising out of so and so, lordship, passed the following order dated April 22, 2009.
Yes.
Okay.
Carry on.
A. The circular dated 17/3/1995 is quashed. The appellants shall not be subjected to annual terminations and reappointments. That annual terminations was quashed. Then B. The benefit of this order will be available to other similarly situated ad hoc border staff, even if they have not approached the court for relief. In view of the above, the interlocutory elections for implementing are disposed of as they become infructuous. C. This order will not, however, come in the way of ad hoc employees working of border staff being subjected to any periodical medical examination or service review to assess their fitness and suitability continuation. The relevant portion is, lordship, thereafter page 72.
Hmm. Yes.
It says, lordship, therefore, considering the facts and circumstances and after due consultation with the various departments, the governor of Assam is pleased to order as follows. The circular dated 17/3/1995 issued by the Inspector General of Police Border is quashed ab initio. Lordship, 17/3/1995 says about the termination annually, that is renewal of the contract. That has been quashed by the Honorable Supreme Court. Then, lordship. 2. Lordship, all ex-servicemen appointed under the additional PIF scheme, that is prevention of infiltration of foreigners scheme, will get the benefit of time scale of pay with effect from the date of their initial appointment. Their pay shall be fixed at minimum of the pay scale on the date of initial appointment. Thereafter, annual increments shall be granted as admissible. They shall be treated as employees against the temporary post co-terminus with the additional PIF scheme of the government of India. Then at 5, serial number 5. Then yeah, serial number 4 area has also been taken care of. But Lordship, in serial number 5, it said ex-servicemen would also be entitled to pension against their services in civil employment, subject to completion of qualifying service as per the Rule 176 of Assam Pension Rule 1969. Here, Lordship, due to the non-regularization of that period, my survey, I have not been granted the proportionate pension, which is I am entitled to as per the Lordship Government of Assam notification, Lordship, dated of 2019. It is here, Lordship. In
Where is
2000,
the governor's notification with that?
Lordship,
You just read out, where is that
it
page
is
number?
at page 70, starts from page 70, and I read out at page 70 to the relevant. It is the operative portion.
70. Yes, then what is this order?
This order is to grant lordship to the ex-servicemen under PIF lordship scheme to grant the proportionate pension also, because here the petitioner has not completed the minimum qualifying service of 20 years, and he will be completing lordship 15 years if that discontinuation period is regularized. Lordship. So that if that period is regularized lordship, then he will be getting the proportionate pension in terms of this guideline. And in the item number 14, whose name is also, was also there, Lordship, in the same list of discontinuation, he has been granted pension because he has completed 20 years of service and he is receiving Lordship. So that matter has become infrastructure. Item number 14.
What do you say, Mr. Boro?
In the penultimate para Lordship, it is in the of the notification that I have, it is clearly written, the provision is not applicable to those ex-servicemen who were appointed under PIF scheme on or after 1/2005. He was appointed in 2000, Lordship. And in the Lordship second paragraph, it is given Lordship. However, the benefit shall be effective with effect on 15 as decided by the government. It is clearly stated that the proportionate pension is entitled by the notification of 2019. And governor has clearly at paragraph serial number 5, governor has that entitled for pension also, and pay scale, everything has been decided in terms of the Honorable Supreme Court order. And the scheme is still going on. And the funding was given by initially Lordship that reimbursed by the central government. So area was not given to me since the central government council was not a party initially. Then subsequently they were made a party. Right. Will terminate. Lordship, but subsequently that has been Lordship condoned.
No, but it was set aside by the
Yes.
single bench. You come to the order, come to page number 41.
Paragraph 12.
Yes. It has been interfered with, set aside and quashed. Order to decision to discontinue the services is set aside. Only thing is that their reinstatement will not be automatic.
Yeah.
It is subject to medical fitness. Right. So if they were reinstated, then you have to regularize that period.
They have already regularized. Lordship.
Hmm?
40 lordship, there are 8 of the adjustments.
Page 40.
40. There are 8.
Hmm. You are reading from?
There are 8.
Mhm.
8 4.
In this context, yes.
Yes. Right. 8.
Then but back wages were not directed.
Not.
So what order are you trying?
We approached for back wages of honorable court lordship. The order have been, but that were not given.
Then against that, who went to the Supreme Court?
Lordship, similarly situated persons, they went to the Supreme Court challenging the clauses that annual termination clause, and that was set aside. And Lordship made the Lordship, and it was and subsequently in terms of that order that continuation was granted, regularization was granted by the honorable governor. Lordship may
No, prior to Supreme Court,
Yes.
this High Court rejected.
prior to Supreme Court, those persons, Lordship, who approached this honorable court, who approached the Supreme Court, Lordship, they approached honorable court in another set of.
That was rejected.
It was initially, it was given, they have been given benefit by the Lordship honorable single judge.
Then
Then
why
against
did they
the
go in appeal?
Lordship,
Then what happened?
then against that honorable single judge judgment, Lordship, the appeal was preferred by the government. Then it was Lordship again rejected. Then thereafter the honorable went to that set of petitioners went to the honorable Supreme Court. And honorable Supreme Court held that their regulation is they are entitled for regularization. That observation also given in paragraph 9 of the honorable Supreme Court judgment clearly. Our High Court in fact judgment Lordship clearly stated that the discontinuation part has been set aside. So we are not claiming now the area. Since all the other persons are getting Lordship, similar to those where 4 persons were discontinued initially for absence for 4 days, Lordship, which was subsequently condoned by the department. This means the continuation is there, Lord.
This scheme is still going on.
Lordship.
Is the scheme still going on?
Yes, Lord. So it has been Honorable Supreme Court has held that it is the appointments are coterminous with the. And thereafter, in terms of that, the judicial department also given, they have given their observation, Lordship, which is there at page, Lordship. Observation, page 69, observation of the judicial department regarding the regularization of these people, Lordship, page 69.
Which one? Hmm. 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 He has been subjected,
Yes, sir.
found fit.
Continue.
No, but the earlier period has been set aside. Earlier period has been set aside.
Taking into account of this Honorable Court judgment, both judicial department and government of Assam, the Honorable Governor also passed the order. Where both in both the orders, the Honorable Court order.
See, you came before the court having certain grievances. Those have been answered in your favor. Similar set of people went from High Court to the Supreme Court. Their answers have been, their
That's right.
reliefs have been granted.
Yes, sir.
Now you are in service.
I retired, sir, in 2016.
You have retired.
In 2016.
You were in service.
Yes.
But whether that particular period is to be regularized or not,
Not.
ought to have been indicated in the order which was given in your favor.
Lordship, at that time, yes, it is, since it is continued. The order, they have condoned that absence period. And
They have, but then your they said you are not entitled to the back wages.
Yes, Lordship, I am not claiming the back wages, sir.
That's the whole issue. If you are deemed to be in service,
Yes, Lordship.
you would ought to have been entitled to the benefit.
Lordship, there is no work, no pay, therefore that has been not.
Correct. We agree with that.
Yes, Lordship. That is the reason, and Lordship may.
There is no specific finding that yes, it can be interpreted that yes, having been set aside,
yes, sir.
you are now taken back into service,
Yes, sir.
etc.
Yes, sir. And similar persons who were, Lordship, the second, that Harmeshwar Boru, that second case, he was also, Lordship, initially that discontinued, then by same order, he has been, Lordship, now he is enjoying pension, Lordship. He is getting pension. Because he has
Now against this, have you filed any representation before the authorities?
Which one, Lord? Against which order?
Against your claim that this period has not been regularized.
Lordship, this petition was filed for that, praying for that, Lordship.
Prior to filing the writ petition,
Lordship.
you were a party before the court, isn't it? Page number 35.
Page number 35, Lordship.
You are a party.
Yes, Lordship. I was.
So this order has come in your favor.
Yes, Lord.
Was any appeal preferred against that? Against this order?
No, Lord.
So it has attained finality.
Yes, Lord.
Now, after you're being taken into service,
Lordship.
the fact that the period of discontinuation was not regularized,
Lordship.
have you filed any application?
No, Lordship, it was, at that time, it was not known because we have been reinstated. We all were in understanding that we have been since reinstated and our, that period of 4 days absence was also condoned at page, Lordship. It is in page, specific order is there, like page 32. They have condoned and they have treated it as leave without pay. It means continuation is there. In the second para also they have
Now,
further
where
clarified,
is it rejected?
Lordship.
Where is the rejection order? Where is the order saying?
Rejection, that page 31, that Lordship.
No, no, where is the order saying that this period is not to be counted?
No, not yet, because I have not been granted pension till,
That is your, but there's no specific order.
no, nothing has been given.
Have you not represented before the authorities?
Thereafter, after retirement, I have not represented.
Have you approached the authorities?
Thereafter, not.
Then on what ground it
I
is not?
will then obtain instruction from them whether they have approached, if they, because since 2012 there is no connection. I'll obtain whether they have approached one. Yeah. Since lots of the other persons are getting the pension also.
Other
since-
persons may be getting, your case may be something else,
Yes,
unless you,
my case is that I have not completed that qualifying service of 20 years. I have
on what basis are you saying that?
because Lordship,
Is there any order rejecting your claim?
No, Lord, I'll have to.
Then?
Lordship, I'll take the information.
Mr. Borua, you can find out perhaps
Yes,
whether he has been granted pension or not, and if not, why not?
yes, why not? Definitely.
Can you do it? It's a 2012 matter, so can you get it done within a week? Within 1 week? The writ petition has been filed by the petitioner praying for a direction to the respondent authority to regularize the period of discontinuation from his service, which was earlier interfered with by orders passed by this court in WPC number
Lordship, the application number.
so and so.
Okay. 2362 and 2006. Lordship.
2362 of 2006
It was Lordship in a batch of petition order. was-
and the connected batch of writ petition. Stop. By the said order, the discontinuation was set aside, but back wages were not ordered to be paid. The reinstatement of services of the petitioners were also directed, but subject to evaluation of medical fitness. Stop. Similarly situated persons who had earlier approached this court, being aggrieved by certain orders passed by this court, had approached the apex court, and the apex court, by judgment and order dated 22nd of April 2009, rendered in MD Abdul Qadir, had directed regularization of, had interfered with such discontinuation and further directed regularization of the people who have put in long years of service. The appeal was allowed by the apex court in part with the following directions. Page number 54, para 10, extract Roman 1, 2, 3. Stop. The learned counsel, para learned counsel for the petitioner submits that other similarly situated, although he was reinstated in, although he was allowed to continue with his services, he in the meantime superannuated.
No.
When?
In the year 2016, Lordship, I could not.
2000?
2016.
16.
Could not get that date.
No, then why did he file this writ petition?
Lordship. 2012.
You're right. The pursuant to the directions of the apex court, the petitioner approached this court for a second time praying for grant of the relief as had been granted to other similarly situated persons by the apex court. And a further prayer for release of his back wages. As the discontinuation of service order was interfered with by this court on the earlier round of litigation. Stop. Where Mr. Tobildar, learned counsel for the petitioner, submits that in the meantime, sometime in the year 2016, the petitioner superannuated from service, and however, he has not been granted pension as had been granted to other similarly situated persons. So, Mr. Tobildar has referred to an office memorandum dated 21st of January 2019, whereby the cabinet decision taken by the state for granting pensionary admissible proportionate pension and other admissible pensionary benefits to ex-servicemen like the petitioner, who had retired from the Assam Police Border Organization under Prevention of Infiltration of Foreigners within bracket PIF scheme, rendering more than 10 years but less than 20 years of service from their date of initial appointment under this scheme was relaxed as a special case and not to be treated as a precedent. Stop. The petitioner is aggrieved that in addition to the reliefs, the petitioner, learned counsel for the petitioner submits that in addition to the prayers made in the writ petition, he also submits that the benefit of the OM dated 21st of January 2019 be conferred on the petitioner as he is similarly situated like the other ex-servicemen who were engaged under the PIF scheme and who had been given the benefit. Stop. It is submitted by the learned counsel for the petitioner that the apprehension of the petitioner is that he has not been granted his pensionary benefit because of non-regularization of his services which he had rendered. A non-regularization of his services for the period he was discontinued from service, and which discontinuation was interfered with by this court by judgment and order dated
2/6/2010.
2/6/2010, passed in WPC 2362 of 2006 and other connected writ petition. Mr. Tobildar, however, submits that he would like to complete the updated instructions from his client to find out whether in the meantime he has been granted any pension. Stop. Mr. Borua, learned government advocate, submits that he would also endeavor to obtain the required instructions and place it before the court. Accordingly, let the matters be listed again after 2 weeks, give date after 2 weeks.
Mandra.
13 October.
13 হলো না।
You want it later?
After 13 that's any
After 13.
any day. Because 13 I got some perspective.
After 13th and 17th, 17th October. Meanwhile, next item has become infructuous.
Infrastructure, but that let it be there now. Because
All right,
he has
item,
got pension,
yes,
he has got pension and instruction was also, I think,
all right. Then item 13, 14 to be listed on 17, 10.
17 October.
Yes.
Obliged, Lordship.
Yes, Mr. Chisti, what has happened? So, but if you file a review, appeal, whatever is there, but you can't sit on this order.
Oh, there is no stay order admittedly. So in view of that, the order passed by this honorable court has been not complied. It is violation of the order, Malad. And he took
No, but
time every occasion,
provincialization
2 weeks
matters.
time, 2 weeks time, Malad. Now he is coming with
No,
a
no, no.
new.
Provincialization matters means the matters where the virus of the act is challenged. This is not a virus challenge act matter. Any notification to that effect? Is there any notification to that effect? You show us that order if it is there. You show us that order. You get it on Friday, we'll show us that order. Let it be on Friday, Mr. Goswami. Let him. If there is an order, then we obviously can't take it.
But the order is in not complied since.
Or tomorrow, if you have it,
Yellow says that is why I pointed out.
have it
that-
tomorrow. If you have that order, all right, then we'll take it up on Friday. You take it, and if you have a copy, you can at least furnish it to the court master, mentioning the item number.
Wednesday or Friday, Malad?
Friday.
Right.
Right. Mr. SMT Chisti submits that an order has been passed by the Chief Justice, Honorable Chief Justice, directing all provincialization matters to be placed before a special bench. A special division bench. Stop. Mr. Chisti seeks a day's time to furnish a copy of this order. Let the matter be listed on Friday. Mr. UK Goswami will counsel for the appears for the counsel for the petitioner on Friday.
Please. We are challenging your lordship order of removal from service without disqualification. Petitioner was a bank employee. What happened to your lordship? Take your lordship to the annexure first. Annexure. For your lordship in annexure 4, page 30. Annexure 4, page 30.
Annexure 4.
Lordship,
Yes.
this is a loan sanction letter. 2 loans were sanctioned in the name of the petitioner. He was a peon in the Assam Gramin.
He was a peon.
Peon, messenger,
The petitioner was a peon.
peon.
How can he sanction loan?
No, it was sanctioned in his name. He applied
Ah,
in the bank itself where he was working.
he applied for a loan.
He applied for a loan. 2 loans were sanctioned in his name. Annexure 4 and Annexure 5, your lordship, both totaling to 2.8 lakh. was a home loan, your lordship, for repair of work of his home he had taken. Now the money, your lordship, he did not start the construction immediately. So what he did, he opened the investment account in the bank. He submitted the amount to RIPC, your lordship, to an investment scheme, reinvestment certificate, your lordship, annexure 6, page 40. Here the issue started, your lordship. This is the document, 2011-2006.
Hmm.
It deposited, your lordship, and this is account number 1833 in his name, Turen Bormon. He deposited rupees 50,000 and he was supposed to get 1,02,116 rupees after a period that is mentioned in the next page. Page 41. What you will see, date of opening is 2011-2006 at the above. Certificate issued price is 50,000. Maturity value is this, 8 years, 3 months period. After a period of 8 years, 3 months, he was supposed to get 1,02,000. But what happened, your lordship, he prematurely he closed the account. On 11/12/2007, there is an entry here in the details. He received an amount of 53,593. Now, your lordship, this account, this amount was not deposited in the bank. That is the allegation, your lordship.
Which amount? 53?
50,000. This investment,
Huh.
what he had done, 50,000 he has invested and he has taken out 53,000.
No. I have not understood. Come to page number 40.
Lordship,
40 is for what amount?
50,000 he has deposited, your lordship.
No. It's for 1,02,000.
Yes. That is, your lordship, it says that upon presentation and surrender of this certificate at this branch on or after, the date is not given here.
Okay.
So,
So he has invested 50,000, which will
50,000.
become 1 lakh something after
8 years. 3 months.
after 8 years.
8 years, 3 months.
All right.
So this amount, your lordship,
Hmm.
is in dispute, whether it was deposited or not. That is the issue.
Deposited where?
In the bank at the time of issuance of the certificate.
Okay.
That is the issue. The allegation by the bank is that we had defrauded the bank. by
Now
the-
this was to be deposited through his account or he has to deposit over the counter?
That's what, your lordship. He had annexure, page 43 will make it clear. Annexure 7. Now, he had given a representation upon when he came to learn about this discrepancy.
Hmm.
He gave an representation on 7/5/2008
Hmm.
to the officer in charge, Nalbari branch, regional office, Nalbari. With due respect, I beg to inform you that in the year 2006, on different dates, I opened 4 numbers of RIPC amounting to rupees 50,000, that is 2 lakhs, and 1 number of RIPC amounting to rupees 80,000. So in all 2,80,000, that is the loan amount which was sanctioned in scheme. Although it was supposed to be 3 numbers of RIPC amounting to rupees 50,000, mistakenly 4 numbers of RIPC were issued. I have detected the said anomaly now only while checking the balance, and as such, I request your kind authority to adjust the said RIPC against a RIPC amounting to rupees 50,000 in my name. So
He opened 4 RIPC.
4 RIPC. He had applied for 4, and this 4 of 50,000 and 1 for 80,000, 2,80,000. What had happened? Only 3 were issued. Sorry, it was supposed to be 3, but 4 were issued. So 1 was in excess. So this fact he came to know later on. When he checked-
No. He opened 4 RIPC of 50,000, 1 of 80,000.
Yes, your lord.
So he's entitled to 4 RIPC of 50,000
Yes, your lord.
and 1 RIPC of 80,000.
80,000.
So why does he say that although it was supposed to be 3 numbers?
Yes, this is the, your lordship, what had happened. This regional officer, when he came to know about it, he influenced him that you give an representation for depositing the 50,000, that it was a mistake, and you give the 50,000 and the case will be closed.
I have
that-
not understood what you are trying to say. You read the opening line.
Yes, your lord.
On different dates, he opened 4 RIPC amounting to 50,000.
Yes.
So which means it's 2 lakhs
2 lakh.
and one for RIPC for 80,000.
Yes.
2 lakh 80,000.
Yes. Sir.
Now, why does he say it is supposed to be 3 numbers of RIPC amounting to 50,000? Mistakenly 4 was issued. He had opened 4.
For that, your lordship, for paragraph 7, I have given the explanation.
Huh?
Paragraph 7 of my repetition at page 9, your lordship. What has happened? His officers above him forced him to give this representation.
Oh, for what purpose?
So, for your lordship, the paragraph 7 will make it clear. Page 9. That the petitioner states that after the aforesaid withdrawal of the RSPC amount on 14/12/2007, it was subsequently found by the bank authorities that the initial investment of rupees 50,000 was not transferred to the RIPC account of the petitioner. The aforesaid aspect of the matter was informed to the petitioner by one Sri So-and-so, who worked in the regional office of the AGVP Bank at Nalbari, who had personally came from Nalbari to meet the petitioner while he was on duty in the Koitalkosi branch of the bank. The said Sri Ravindranath Sharma further advised the petitioner to prepare a representation before the officer in charge, Nalbari, for refunding the amount mistakenly withdrawn by him. The petitioner, genuinely believing that the amount has been misplaced or laundered by the then branch manager, and in the process caused loss to the bank, agreed to the process for
This doesn't clear up. This doesn't clear up.
what had happened is Ravindranath Sharma, he is the inspection officer. So he went to the
How many RIPCs did your client open?
Lordship.
How many RIPCs did he open?
He applied for 4
How can it be 4?
because what had happened, only but amount was deposited only for 3. One amount was not deposited. 4 were issued. 4 were issued
By whom? By the bank.
By the bank. By
Ah.
the branch manager. 4 were issued,
Ah.
but amount was only submitted for 3. So 50,000 amount was missing.
Who submitted the amount?
Uh,
Who did not submit the amount?
The allegation is that I have defrauded. That is the
Naturally.
Yes, Your Lordship. But what had happened, Your Lordship, the branch manager, I had given an application that the amount which is lying in my loan account, COD account, that should be transferred to the RIPC account. No, it was not by way of cash. Your Lordship. That withdrawal form was there. That on that premise, the entire disciplinary proceeding took place. To take Your Lordship to the show cause, Your Lordship. Now, after this, in the month of May, Annexure 8, Your Lordship, will be on page 44.
I don't think you really have a case. Sorry.
Lordship, procedural.
Tell us where is the procedural
Yes, Your
or what is there? I mean, what kind of an explanation is this? That you take a loan from the bank,
Yes, Your Lordship.
you put the money in the RIDC,
Yeah, RIPC.
and then in the 4 RIDCs you pay money for 3, and then you write a letter saying that you deduct it from my. What kind of explanation is this? And you are a bank employee.
Bank employee, yes, it's true, Your Lordship. But
Then?
what had happened, Your Lordship, Annexure 8, page 44, will make it clear. Now, 27 August 2008, they proceeded with the inquiry. They served the allegation letter, Your Lordship, or a show cause. It is alleged that during your tenure as messenger of Kalitakuchi branch, you committed serious irregularities as stated below. You opened the RIPC account bearing number so and so in your name in the branch on 2011-2006 for rupees 50,000. No amount was deposited by you against the state reinvestment plan account. The receipt bearing number so and so was written by you, and it was subsequently signed issued by the branch manager against the state RIPC account after making entry in account opening register and ledger. It is alleged that the entries were made by yourself in the ledger sheet and RIP certificate. The account was prematurely closed by you on 14/12/2007, and a sum of rupees so and so was credited to your COD account number 3 maintained with the branch. On verification, it was found that on the day of opening of the account, that is 2011-2006, you did not deposit any amount for the state RIPC. The amount is neither entered in the cash book nor cash scroll register of the bank. From the above, it is evident that you have defrauded the bank by so and so for your personal gain. Under the circumstances stated above, you are advised to explain your conduct and show cause as to why appropriate disciplinary action will not be initiated against you.
This is a serious allegation.
Lordship. This is the allegation, Your Lordship.
Then
Now, Your Lordship may kindly
what is your reply?
reply, Your Lordship. I have annexed. Now, before the reply, another notice was served on me. That I have annexed at page 45, annexure 9. So, 30 August 2008, 3 days later. This is with reference to your
Page number?
page 45, next page. Your Lordship. Annexure
45.
9. Before
Yes.
I could reply, this was again served. With reference to your above mentioned withdrawal of RIPC number so and so on 14/12/2007, we are going to calculate the interest from the date of opening of the said fraud account in your name with effect from 2011-2006 at the rate of COD loan, where you have to refund an amount of rupees 12,116, and on the other hand, as per your undertaking to adjust the fraud RIPC with your another account, we have closed the same and you will get interest amount rupees so and so. Therefore, we request you to refund the differential amount of rupees 5660 only immediately at your Kaitalkuchi branch. This amount was refunded after my undertaking. And what the bank had done, this RIPC, they had converted it into a loan account. And the interest was calculated for the entire period, which was 12,116. So after deduction from my another RIPC, 5,660 was outstanding, which again I paid in cash after this notice.
The amount may have been made up, but the conduct, your conduct.
Lordship, conduct, Your Lordship, that is the allegation, not yet
Yes,
proved, Your
madam, what do you say?
Lordship. Lordship may kindly come to my reply. Actually, and the inquiry in which manner they have presumed me to be guilty.
Of course, you're guilty.
No, Your Lordship, but
The
that
prima
cannot-
facie, it appears.
that has to be proved, Your Lordship, because he stand, Your Lordship.
You had issued a letter saying that you deducted
No,
amount.
I had not issued, Your Lordship. The branch manager had issued. I am only a peon, Your Lordship.
No, where is that letter?
But because only for the sake of honesty, because
Where
he
is
was
the
honest.
letter?
Lordship, letter is that that RIPC, Your Lordship.
No. Some reply letter you had given.
Reply, I representation, Your Lordship.
Yes. Where is that representation?
Page 43, Your Lordship.
40?
43.
You adjust the RIPC against that RIPC of so and so. You have admitted. What else is there?
Yes, there that I have not admitted as to the guilt, Your Lordship. Only there is a
No, you have admitted to a discrepancy,
anomaly, Your Lordship.
anomaly. Now,
But
this anomaly, they
whether-
have stated that you have written it with your own hand.
That's what, Your Lordship. I have stated that this was Rabindranath Sharma, Your Lordship. This was addressed to Rabindranath Sharma. He is again a management witness in the inquiry, Your Lordship. That I will place, Your Lordship. If the Lordship may kindly come back to his reply.
Anyway, madam, are the records available? So what do you say? Huh? I didn't get you. Sorry? Who? All right, we'll take it up on Thursday. Keep the records. Thursday? You have informed him? Yes.
Your Lordship. Page 46 is the reply, Your Lordship. Go first.
46.
Here, I beg to state that while I was posted at Kaitalkuchi branch, I deposited rupees
What
50,000.
is 46? What is this?
This is reply to the show cause, Your Lordship.
Reply to the
Show cause. There were two show causes, Your Lordship. This is the first show cause. This is the reply. I beg to state that while I was posted at Kaitalkuchi branch, I deposited rupees 50,000 in a reinvestment.
What
plan
is
that-
COD? What is COD account?
This is some banking term cash overdraft account, loan account. It is worth mentioning that at the relevant point of time, an housing loan amount of rupees 1,50,000 was credited to my COD account. Number 3. But due to some special difficulties, I could not construct my house, and apprehending that the money might be spent unutilized, I kept it fixed deposit. To open the said RIPC of rupees 50,000, I submitted a withdrawal form
to debit the said money from my COD account number 3, but mistakenly the withdrawal form remained without being entered in COD 3. Thereafter, whenever I was in need of money, I used to withdraw money from my COD 3, but since the account remained unchecked, I did not know that the rupees 50,000 withdrawal form was not entered. So till date, I have been rendering my services to the bank with honesty. This is an unintentional mistake on my part. Already, I have deposited the said money along with interest thereon in the Koitalkasi branch as directed by the branch manager. Lordship,
This is your reply to the show cause.
show cause. Then
Where is the inquiry report?
then another show cause was issued, Your Lordship. After this reply, nothing for 2 years, Your Lordship. This was in,
Then
I replied in October.
Hmm.
Then again, page 48, they issued another show.
these are the articles of charge.
Articles of charge, Your Lordship, more of a, oh, Your Lordship, it can be said to be a charge sheet. This article of charge, Your Lordship, 1, on 2011-2006, you opened the RIPC account so and so. You deposited no amount against the said RIPC. A receipt bearing number was written by you and subsequently it was signed, issued by the branch manager against the said account. All the entries were made by you in the ledger and RIPC account, which were duly authenticated by the branch manager, was prematurely closed by you on 14/12/2007, and a sum of rupees so and so was credited to your own COD account number 3 maintained with the branch. Thus, you defrauded the bank's money to the extent of so and so in connivance with the branch manager. But the branch manager was not proceeded against him. No DP drawn against him. Only I was proceeded against in punishment. So far as the instruction I have received. Lordship, now page 49, your Lordship will see the list of documents and list of witnesses. A list of documents, your Lordship, they have referred to a cash book. The first is charge sheet, second is acknowledgement, reply. Cash book will find at 8 and 9. Now, your Lordship, we had submitted a withdrawal form. My plea was that I had submitted a withdrawal form. Now the question of a cash deposit being made and an entry to that effect in to be recorded in the case book, that does not arise. There will be no entry in the cash book because I had asked that the money be transferred from my loan account to the RIPC account. That was the application. And your Lordship, in the list of witness, your Lordship will see Sri Ravindranath Sharma. Only one witness was placed. Now, he was the person who influenced me to give that representation. That you give this representation, you refund the amount to the bank, we will not proceed any further. This will be closed. Only to protect the bank manager, your Lordship. Otherwise, if I would have said that no, I don't know, I had deposited the money, the bank manager would have been responsible. If I only because of my honesty, I am in this state. Because I honestly said that there may be a mistake. This amount may not be deposited, so it may be adjusted from my account. But if I would have
No,
taken,
but tell me one thing. You are the beneficiary of the RIDC.
Yes.
So in your reply, you said you opened only one,
yes, sir.
50,000.
So 4 but 3 were
Hmm?
3.
So
So-
go to your reply,
Yes, sir.
page number.
Page 46. Your Lordship. Because in the show cause there is only mention of one RIP.
See,
Yes,
page number 46 is your reply.
reply.
Now in your reply, you mentioned only about 150,000.
Yes, Your Lordship. But the loan amount is mentioned here. One
Loan
lakh
amount is mentioned.
and another COD account.
Huh?
Yes, Your Lordship. This is mentioned.
It said loan amount.
Yes, sir.
You took loan amount of 1,50,000.
Yes.
You could not construct.
Could not.
Therefore, you kept it fixed
Fixed
deposit. Then to open the said RIC of 50,000.
Yes.
Now it's not clear.
Because in the show cause only in respect of one they had. In the show cause, if page 44, only one RIPC. So only in respect of one he has given the reply. But from the earlier representation, which
What is
not
the meaning of the sentences towards the end of the paragraph,
Lordship,
first paragraph?
in my reply,
Yes.
first paragraph, Your Lordship. But
Hmm.
mistakenly the withdrawal
Yes.
form remained without being entered in COD3. So thereafter, I used to withdraw money from my CODT, but since the account remained intact, I did not know. Withdrawal form was not entered.
What is the meaning of this?
Lordship, what the meaning would be that RIPC was to be issued from COD3 account. But he was not aware that the money was not transferred.
How do you open the RIPC account?
RIPC account. Your Lordship.
What is the procedure?
That I'm not aware. That
You are an employee of the bank. How is it that you are not aware?
Lordship, he may be aware, but I don't have instruction to do that because
Yes, Mr. Dotto. He says you have settled all the burden of the person responsible is the branch manager, and because of his mistakes, this fellow has been burdened. Charges we have seen.
what
How are these accounts open? Only by cash deposit? Uh, hmm.
He has opened that account. Funded the amount as
How?
now. Fund the amount.
No, how did he refund the amount?
By given the amount by way of
Cash.
that is reflected in the account. I kept the record that show that he paid that. Then start the
Yes, yes.
Sir.
What do you say?
This is only the allegation, Your Lordship.
No, he
Nothing-
says it is evident in the records.
No, Your Lordship may kindly come to the inquiry report. Inquiry report, what they have done, only one-page report they have written.
1 page, half page, 20 page, how does this matter? You
Lordship,
tell us.
no finding, nothing, no finding on what basis the findings were arrived at. Nothing is there, Your Lordship. This will vitiate the entire DP, Your Lordship. Your Lordship, page 53, Your Lordship may kindly come.
Hmm.
This is the forwarding for submission of inquiry report.
Hmm.
This is with reference to the above. I would like to state that I was appointed inquiry officer by later dated so-and-so to inquire into the charge level against Sri so-and-so. Sri Jogen Dotto was appointed presenting officer to present the bank's case before the inquiry. The preliminary hearing was conducted on 24/12/2010 at Nalbari. Sri Pavitra Kumar Bormon of Marua branch was appointed defense representative by the petitioner to assist by the Bank Employer Association to assist the charge sheeted employee. The other hearings were conducted on the following dates: 1, 2, and 3 dates are given. This is the only the forwarding, Your Lordship. Now the report, Your Lordship will find
53.
53, 54, Your Lordship will see the last part. This is list of witness Ravindranath Sharma. CSC submitted a certificate of inspection of documents on so-and-so. Presenting officer presented the case before the inquiry through management witness Sri Ravindranath Sharma. Now, the presenting officer did not present the case. Your Lordship. From the record, it is apparent that the management witness Sri Ravindranath Sharma had presented the case. And management witness explained before the inquiry the charge leveled against the CSC through exhibits and tried to prove the charge. So the witness tried to prove the charge, Your Lordship, not the presenting officer. And thereafter, the DR cross-examined the management witness as detailed in the proceedings. After cross-examination, PO submitted his summary verbally, but the DR did not submit his summary verbally. The hearing came to an end on so and so. So PO submitted his written brief after a few days with a copy to DR, but the DR submitted his resume on 12/6/2011 only. Now, next page, Your Lordship will find the inquiry report, page 55. Here the charge is discussed under one head. PO's brief is given, the presenting officer's brief is given, defense representative's argument is given. Now, inquiry officer's finding, Your Lordship, how the findings were arrived at. Just simply he has stated, in support of the charge, PO presented to management, which is the management exhibit from 3 to 11. The exhibits clearly indicate the irregularities were committed by the CSP. How, Your Lordship? No finding, no reasoning has been given. Only this finding he has given. How he has arrived at this finding, nothing, no discussion at all. On what basis, what did the witness say, what were the documents exhibited, and how it has proved that I have committed the irregularity, nothing on record. Now, DR could not produce any proof that CSC requested the concerned official to deduct the amount from his POD account number 3. From the PO's brief, it is evidently clear that CSC committed the same with his manifest intention, so charge is fully accepted. Only this part is the finding. How he has arrived, no discussions at all in the inquiry report. Now, the second part, Your Lordship, next page, page 56. Thereafter, the inquiry report was given to me to give my written statement that I have submitted, Your Lordship. Now, the punishment order. Page 60. Tentatively it was decided, Your Lordship, by this punishment order 7/10/2011. Lordship has page 60, that fourth paragraph, Your Lordship. After considering the facts and circumstances of the case, the gravity of misconduct and your past record, it has been tentatively decided by me to impose upon you the following punishment: removable from service, which shall not be a disqualification for future employment. But before I take a final decision with regard to the punishment as stated above, you are hereby given an opportunity of being heard personally. So that was given, Your Lordship. I appeared. Thereafter, the final order was passed.
62.
Page 62, Your Lordship. Without any discussion, Your Lordship. The penalty was imposed. Why the inquiry report was accepted? Only the punishment was conveyed to me, Your Lordship. I was removed. I filed an appeal. Page 63, 64, Your Lordship. Page 65, the appellate authority is the board of directors of the bank. They have also passed the cryptic order saying that there is no merit in your appeal, so they have dismissed without any discussion. Only one page. Now, Your Lordship, I kindly, and in reliance of my submissions, Your Lordship, I want to place some judgment, Your Lordship. 2 points, Your Lordship, I am relying on primarily. One is irregularity in the inquiry, Your Lordship, and Lordship, may I give some citation?
Yes.
Bank account without- Okay,
No, no.
first I want to say reliance on the judgment of Rup Singh Negi, Your Lordship, 2009, USCC 570. Lordship has it.
Yes.
Lordship, paragraph 14 and 15, Your Lordship, and 23. I'm relying upon. Paragraph 14. May I read? Indisputably, a departmental proceeding is a quasi-judicial proceeding. The enquiry officer performs a quasi-judicial function. The charges leveled against the delinquent officer must be found to have been proved. The enquiry officer has a duty to arrive at a finding upon taking into consideration the materials brought on record by the parties. The purported evidence collected during investigation by the investigating officer against all the accused by itself could not be treated to be evidence in the disciplinary proceeding. No witness was examined to prove the said documents. The management witness merely tendered the documents and did not prove the contents thereof. Reliance inter alia was placed by the inquiry of, this is not relevant here. Paragraph 15, Your Lordship, again. We have noticed herein before that the only basic evidence whereupon reliance has been placed by the inquiry officer was the purported confession made by the appellant before the police. According to the appellant, he was forced to sign on the said confession as he was tortured in the police station. The appellant being an employee of the bank, the said confession should have been proved. Some evidence should have been brought on record to show that he had indulged in stealing the bank draft book. Admittedly, there was no direct evidence. Further, there was no indirect evidence. The tenor of the report demonstrates that the inquiry officer had made up his mind to find him guilty, as otherwise he would not have proceeded on the basis that the offense was committed in such a manner that no evidence was left. This is in respect of the inquiry report. Paragraph 23. This
Yes.
is in respect of the order passed by disciplinary authority and appellate authority. Furthermore, the order of the disciplinary authority as also the appellate authority are not supported by any reason. As the orders passed by them have severe civil consequences, appropriate reasons should have been assigned. If the inquiry officer had relied upon the confession made by the appellant, there was no reason as to why the order of discharge passed by the criminal court on the basis of self-same evidence should not have been taken into consideration. The materials brought on record pointing out the guilt are required to be proved. A decision must be arrived at on some evidence which is legally admissible. The provisions of the Evidence Act may not be applicable in a disciplinary proceeding, but the principles of natural justice are. As the report of the inquiry officer was based on merely ipsedistic, as also surmises and conjectures, the same would not have been sustained. The inferences drawn by the inquiry officer apparently were not supported by any evidence. Suspicion, as is well known, however high, can under no circumstances be held to be a substitute for legal proof. Now,
There are later judgments.
Right.
There are later judgments after this. There are later judgments.
yes,
You have to come up with that also.
Lordship, I'll try. But Your Lordship, one more submission. I
But
have to-
one question,
Yes, Your Lordship.
in your reply, you have admitted
Not
that
admitted.
there is a mistake.
There is a mistake. Your Lordship. But whether that mistake was intentional, intention to defraud, that is not admitted. Your Lordship. And
May not be necessary.
that has to be proved. Your Lordship.
Why? Under what provision? You are an
Related
employee of the
to state,
bank.
Your Lordship.
You are an employee of the bank.
Yes, sir. But there was a mistake on the part of manager also, Your Lordship.
The-
Now they are only with all the.
We are going entirely by your reply.
Yes, Your Lordship.
In your reply, you admit that yes, there was a mistake. I have done this, that, I've given an explanation. But there is no further, all right, you are a grade 4 employee, so we'll give that benefit that you could not explain more. But how do you accept the fact that once there is an admission, what further evidence would be necessary to show that that your admission is required to be proved?
Your Lord, that is answered, Your Lordship, in the regulation.
Ah,
That if there is an admission, no further inquiry is required.
right.
In the regulations, but they have proceeded with the inquiry.
Maybe because they wanted to give you an opportunity.
Lordship, but there is no admission, Your Lord. Only that there is.
That is your interpretation, but the reply is a clear admission.
No, Your Lord.
Is a clear admission that yes, there is a
There is a
mistake.
mistake, Your Lord. But
Then
there is no fraud, Your Lordship, on my.
The fraud or
because-
no fraud, who knows?
Yes, that has to be inquired into and proved. Your
No, under the regulations, you point out that uh, proceedings can be initiated only or punishment can be imposed only upon establishment of fraud.
fraud, Your Lordship. Yes, Your Lordship. That is the allegation, defrauding the bank. That they have to
You
prove.
show us
Yes, Your Lordship.
that unless there is a finding in the inquiry
Yes, Your
to the effect that forgery or attempt to defraud the banking a bank
Yeah.
was not established, no punishment can be awarded. You show us from the rules if it is there.
Yes, Your Lord, that's the judgment, Your Lordship, 2009. It says that it has to be proved, Your Lordship, unless and until it is proved.
It has to be proved, but
Proved.
here is a case where it is not, there is no admission.
No, he had admitted before the police, Your Lord. That
You
was-
know better than that.
Yes, Your Lord. But here there is no admission, Your Lord. That's my humble.
There is an admission that yes,
There-
something
there-
happened
there
wrong.
was a mistake, but
Yes.
no fraud, Your Lord. Later on, when they issued the show cause, the fraud part was never admitted. And Your Lordship, moreover, the regulations upon which the bank had proceeded, Your Lordship,
Hmm.
that requires to be under the Regional Rural Banks Act. Your Lordship, I have furnished a copy of the act.
Hmm.
That requires to be placed before the Parliament, Your Lordship, under Section 30, sub-regulation 2. I have checked up, Your Lordship, I have not find any notification to that effect. In that event, Your Lordship, the regulation itself will not have any statutory force. That two judgments of
have-
Allahabad High Court also have been.
Uh,
That correct at all. So that the Lordship understand. Regulation is not required to change the product. There are
I think there is a judgment decision to that effect of the division bench
Yes, yes.
of this court. I think there is, I think
Okay,
there is a judgment to that.
Yes, Your Lord, that I have checked up, Your Lord. That's not, this issue was not raised here.
Is it?
It was only in respect of gratuity, perhaps. Gratuity, gratuity. Act.
Gratuity, perhaps. No, but there is a reference that under this it was required to be placed or something like that.
This was,
this regulation frame, that is the power. On part of section 30. Therefore, my lord, regulation is not required to take to the parliament or either house of the register. Or the- My lord, this regulation is not required. The regulation.
Lord,
That's
section,
why it is called support.
no, Your Lord. I beg to
There is a
differ.
question of law. Correct? They all these-
Section 32, Your Lordship, I am relying, section 30, clause 2.
1 minute.
In very clear terms, it states here. And there are judgments on this point. Power to make regulations, section 30, Your Lordship. This is the power. The board of directors of a regional rural bank may, after
No,
consultation.
this is to be placed before the parliament under provisions of
Section 30, clause 2, Your Lord,
section 30.
clause 2. Clause 2, Your Lordship. Every regulation shall, as soon as may be after it is made under this act by the board of directors, be forwarded to the central government, and that government shall cause a copy of the same to be laid before each house of parliament while it is in session for a total period of 30 days, which may be comprised in one session or in two or more successive sessions. And if before the expiry of the session immediately following the session or the successive sessions aforesaid, both houses agree in making any modification in the regulation, or both houses agree that the regulation should not be made, the regulation shall thereafter have effect only in such modified form or be of no effect as the case may be. So, however, that any such modification or annulment shall be without prejudice to the validity of anything previously done under that act. Now, what will happen if it is not placed, Your Lordship?
Hmm.
Two judgments are there of Allahabad High Court, Your Lordship.
Hmm.
I have given a copy to Your Lordship. One is Satantra Kumar Singh, another is Ashok.
You are
Kumar
referring to section
30
30.
clause 2, Your Lordship.
Clause.
It has to be placed before both the houses, and if not placed, it will not have any effect, Your Lordship.
And what is a regional rural bank?
Regional Rural Bank is, Your Lordship, that Assam Gramin Bank, Deepikas Bank is a regional rural bank. Under the regional, operating under this technique, Your Lordship, Regional Rural Bank Act.
And this regulation under which the disciplinary uh, proceeding was held was framed under section 30 of this act, Your Lordship. 2006 regulation, service regulation. So section 32, Your Lordship, what will be effect? Two judgments I have relied on, Your Lordship.
Yes. Yes.
Lordship, the two judgments I have given, Your Lordship, Swatantra Kumar Singh, Your Lordship.
Yes.
And the second is Ashok Kumar Srivastava. Swatantra Kumar Singh, Your Lordship, paragraph 11 and 12. Citation to interpretation. Swatantra Kumar Singh. Paragraph 11 and 12. May kindly have paragraph 11 and 12. Admittedly, the plaintiff is an employee governed by the Gorakhpur Kshatriya Gramin Bank Staff Service Regulations 1980, framed under Section 30 of the Regional Rural Banks Act 1976. Section 30 in the said act prescribes that the board of directors of a regional rural bank may, after consultation with the sponsor bank and the national bank, and with the previous sanction of the central government by notification in the official gazette, make regulation not inconsistent with the provisions of this act and the rules made thereunder, to provide for all matters for which provision is necessary or expedient for the purpose of giving effect to the provisions of this act. In subsection 2 of the state act, it provides that every regulation so made be forwarded to the central government, which shall lay the same before each of the House of Parliament while in session for a total period of 30 days, and only after the House agrees in making any modification or an annulment by the House, the regulation shall take effect. Next paragraph, Your Lordship, it thus appears from subsection 2 of section 30 of the said act that only when it receives the approval by both houses of parliament, the regulation shall take effect. This means that though it is a subordinate legislation delegated to the board, but the same can be legislated by the board only with the previous sanction of the central government, and the same shall not take effect until it is placed before the both houses of parliament, and the same is voted by both the houses. Thus, by reason of the involvement of the House in making the regulation effective, only after it is approved by the houses, such regulation assumes statutory character. Next.
You share the judgment.
Yes, sir. Ashok Kumar Srivastava, Your Lordship, the next.
Very well, on the same issue. On the same issue.
Same issue, Your Lordship, only 2-3 paragraphs, Your Lordship. Paragraph,
It's on the same proposition, isn't it?
same proposition.
That's all. One judgment is good enough.
Yes, sir. This is more clear, Your Lordship. It discusses the effect.
Give us the paragraph
Paragraph, Your Lordship, 7
in Ashok Kumar.
in Ashok Kumar Srivastava. Paragraph 7. This is the submission. Paragraph 13, 14. Ratio, the acceptance of the
13, 14.
13, 14. Paragraph 7, 13, 14, and 18. 18 is not relevant. 13, 14.
And in the earlier judgment,
Earlier judgment, Your Lordship, paragraph 11 and 12. Swatantra Kumar.
yes.
So this two points I have to urge you. As regards the inquiry report, I have placed the judgment, Your Lordship, and disciplinary authority order and appellate authority order. And the second point is the statutory force, whether the regulations have statutory force.
If the second point is urged, then everything goes.
Everything goes, Your Honor. Everything.
What is the name of the party?
Party, Your Honor. In
Surendranath.
Surendranath Burma.
Yes, Mr. Dotto. Yes. Hmm. Yes.
On 2011 to 6, to open a RIC account. But no amount carry subject branch. All the investors by RIC particular branch. These RIC the sum of that was created for own account, the equity account, pending the branch. The total private branch of detect and now next week the reply by at page 5 dated 77 10. The honor here is my humble starting the effort. The array because I was unintentional on my part. Unfortunately, was submitted by the array. That is the other hand, the array was mine. The branch conflict with both everything is what that was that I want.
So this is okay. We have found it. Now
Yes.
his ground is that your inquiry report does not contain any reasons.
Below that figure is
Sorry.
MLP one. Very tentative at the right line. MLP one rate that account of for the account was occupied that only the handwriting was Amount was the account of was the producer of the account was even he became the
He became the,
he became the used by bank of account.
so he is the, he is the introducer of himself.
That's the then the other part of that regarding the receipt of money. So also have to be pay but the management the cash of they should have right. They should not have to pay that money cash over they should have for the now but it is not very bad. Not the no deny, no such. Now even not volunteer evidence, there is no evidence. So therefore the big proposition so can we say that it was not intended? So his intention was to improve the bank. That's the reason why not he has taken out the big deposit receipt.
Is there a finding that there was a intention to defraud the bank?
You know, the page 55, the code of the inquiry officer. The
Irregularities were committed by CSE DR means? Page number 55 in the EO's finding column,
was finding
if you come,
support of the chart,
hmm,
PO presented from the management agreement from 11 that it chart
okay.
defense representative could not portray that chart deduct the amount of the first the chart now exhibit 11 and showed that denial has been repeated. That it was that the count for get by the account of what is of by 2014 and with the whole thing about that
But all these entries and everything were duly authenticated by the branch manager. Did you initiate any proceeding against the branch manager?
the bank got
This is the PO's brief. No, sorry, this is the charge.
Charge.
You see, all these entries in the ledger and RIPC account opening register, everything was his handwriting, and which were duly authenticated by the branch manager.
What happens?
What is the meaning of this authenticated?
They have to, they have to submit.
No, no, what I'm asking you, is it authenticated in that register?
No, the, say, the big utility for passing it, there will be voucher.
What I want to know is, what is the meaning, exact meaning of this term sentence used here? All the entries made by so-and-so in ledger account and so-and-so were duly authenticated by the branch manager. Is it authentication in those ledgers?
Yes.
Or is it the allegation, the very allegation that these were his handwriting was authenticated by the branch manager?
Actually, the voucher will have to counter by the.
The countersigned is not the word used, authenticated. Is it his handwriting which is authenticated, or the entry in the form is authenticated?
Proper official transaction, any voucher is passed by a clerk will have to be countered by that word what they be countered. They have to be countered by the higher official.
No, if that be so, then the higher officials are in connivance. How could they have countersigned and passed all these documents?
What happens? The
So good faith is okay, but good faith, whether it is good faith or malafide intention, it has to be on the basis of some inquiry. But they were not proceeded against.
that of course whether they have proceeded against the branch or not.
Perhaps not, because they have settled all the responsibility on this employee.
Employee may not be primarily his responsibility. Correct. But then branch manager as a lot of indicated.
No, see, on a date when it was submitted by this person, it was authenticated.
Yes.
Which means on that day it was perfectly in order because it was authenticated.
What say it was countersigned. That was
Purpose of countersigned is verification.
detected letter when he committed.
Correct.
It was not
Correct. So therefore, all persons who are involved or whose signatures are there ought to have been proceeded against to establish that yes, other persons are not there. It is only this person.
approved transfer to the what
Very well. What is that Supreme Court judgment to say that it is not required to be placed before the Parliament?
that
All right. So we continue the hearing on. You give us a date, Thursday. We'll take it up on Thursday.
all right.
Thursday. For further hearing, heard learned counsels for the parties. For further hearing on Thursday. You give us a list of the judgments that you want to rely on. Prior to that, both parties, if any further judgments you want to rely on, give a list to the court master in the morning. Okay, Thursday.
Lordship has kept it a part.
Further hearing, which
Much.
is Yes.
This matter pertains to retention of a family quarter of an constable of an CRPF, Lordship. And on the last occasion, direction. was-
Agartala.
Yes, Lordship.
So you file a representation, they will consider.
Yes, Lordship. And in the meantime, Lordship, till disposal of this petition, Lordship representation, I may be permitted to.
No, then we can't dispose it off. You have to tell us that within a specific time it will be considered. Will he see he is entitled by virtue of this court. By virtue of this court, he is holding by under orders of this court,
Yes, Lordship. And
as well as that interpretation of that
official
circular
memorandum. Yes.
that is not in existence. What does it say? You are saying pursuant to 28 July 2009, subsequent notification has come. You should have brought it on record.
This copy is not available with us.
You furnish a copy or bring it on record.
And the page 32.
Can you bring it on record? MSB Sharma, learned CJC submits that pursuant to pursuant to the SOP dated 28th of July 2009 relating to accommodation rules and allotment and occupation of family accommodation of the CRPF. A subsequent OM dated 2nd September 2022 is now in force, and the earlier SOP is no longer in force. She prays for a short date to bring the same on record. Mr. Mazumdar, Mr. Bezbura, Learned Counsel submits that he does not have a copy and therefore prays that the same be filed by way of an affidavit by the respondents. Prayer of MS Sharma is allowed. Matter be listed after 2 weeks. 28. Already too many matters on 28. We can have it on 3rd. 3rd? All right, 3rd.
Earlier,
List on 3rd.
interim may be continued, Lordship.
Earlier interim orders will continue till the next date
Much.
fixed. Yes.
Lordship, these matters relate to regulation of services of the petitioners who were master roll workers of the Nerivalo. However, Lordship, Mr. M.K. Chaudhary is conducting the cases. However, since he is busy in some official commitments, the Lordship.
Passed over for the day at the request of Mr. So-and-so, as the arguing counsel is not available in court today, only for the day.
Okay.
Yes, 20.
Good matter. They have come with, these are the SPOs. There are two certificates. They have come with two gold prayer. One is to order man, mobile. That, and the second is there is an appeal pending for the I
department. So that should be disposed. That is the for that prayer. I have gone through the affidavit pilot. Pilot peruses para 9 of the affidavit filed by the responsible authority. Para 9, my lord, current that on 34 2012,
Yes.
that was disposed of.
Hmm.
The appeal was disposed of
Para number 9,
para number 9.
appeal. Huh?
That was disposed of. Think thereby, if now the petitioner, my lord, so now it becomes infraction. So now if there is any further challenge, they have to now challenge this
What is the prayer here?
prayer, my lord, page number 10. Sorry.
He is prayed for setting aside the discharge order.
Second fold, my lord. The next. And the response number 4, say that the service is for service still benefit and as to why the further direction cannot be issued to the responsible authority for a fresh decision on the basis of appeal petition.
It's all right. One party is becoming infractious,
Yes.
but discharge order.
So, my lord, once that appeal has been dismissed, they preferred an appeal on the impugn order. So now, my lord, that has been disposed of. So now, my lord, it's a fresh cause of action. If they are really agree, if they have to now challenge that.
No, but their discharge order is still remains. Perhaps it has become infractuous.
Yes,
You can inform the requestee. Naam to padhai diyo. We'll pass it over for the day. None appears for the petitioner. Mr. Radhor appears for the respondent. Matter stands passed over for the day.
Yes, Your Lordship, may kindly pass.
You're making on whose behalf?
On Mr. B. Kaushik. Lordship, he was here in a while ago. Due to some emergency, he had to rush.
At the request of MS so-and-so, matter stands passed over for the day.
Lordship, may fix the date.
No, we are passing it over. You inform me, we'll come and make a mention, we'll see.
Not of later.
Say 22? Okay.